Good morning, everybody. Okay, good morning and welcome to our conference, Victimhood in Times of Hybrid Crisis, AI and Digital Transformation. I'd like to thank everyone for coming here and listening to our speeches. And now I would like to welcome our guest speakers. I'll welcome you one by one so you can say a few brief words. We have 10 minutes here. So first speaker would be the Nikitchenko Olha, the ambassador of Extraordinary and Parliamentary of Ukraine of the Republic of Lithuania. And welcome, and we're very happy to have you here, and you have the floor.
Thank you very much. Distinguished Madam Prosecutor General, esteemed academic community, dear partners and dear friends. It is a sincere pleasure to be here today at Mykolas Romeris University among a community of true friends of Ukraine who stand with us not only in words but in actions. Your support is both visible and deeply felt, from advanced academic cooperation to practical initiatives. And also in very concrete steps, like your recent initiative to collect essential winter supplies for Ukrainians. Thank you so much for that. We also deeply value our growing partnership. It was a particular honor to welcome Mykolas Romeris University at the Global Coalition of Ukrainian Studies, which was recently signed during the visit of the First Lady of Ukraine to Lithuania. And today's conference is another strong sign of your support, especially as it takes place on February 24th, a tragic milestone marking 4 years since the beginning of Russia's full-scale aggression against Ukraine. And it is a very personally hard day for me, because my mind goes back to all that was happening 4 years ago, what was happening to my family, to my friends, to me, and to all of the Ukrainians. So for me, it's the darkest, it's the worst day of the year. And unfortunately, we meet at a time when the word victim is no longer abstract for Ukraine. It is not a concept studied in theory, it is a lived reality for the millions of people. For 4 years of the full-scale war and more than 11 years of the ongoing Russian aggression, Ukraine has been facing a deliberate and systematic campaign of terror. A campaign directed not only against our people, but also against our identity, our infrastructure, our culture, and our very right to exist, and even our memory. And beyond this, Russia is even using winter itself as a weapon, targeting energy and infrastructure, trying to leave people without heat, electricity, the water, basically trying to freeze us into submission. The scale of this is very difficult to perceive and to comprehend. As of 20th of February 2026, Ukrainian law enforcement agencies have registered 216,824 war crimes. And behind this number, there are people. According to the UN Human Rights Monitoring Mission in Ukraine, last year became the deadliest for the civilians since the start of the full-scale war. More than 2,500 civilians were killed, over 12,000 were injured, and among them children. But despite all of this, despite all of the losses, despite all of the pain, despite everything that Ukraine has been going through, we continue to resist. We continue to fight, and we continue to stand. And we do not fit into the mold of the ideal victim, because an ideal victim is expected to suffer passively while the whole world responds with concern and sympathy. But Ukraine did not follow this path. For years, we have been holding off a stronger enemy, long after many expected Ukraine to fall within 3 days, as we remember Kiev in 3 days of the full-scale war. And even more than that, Ukraine has not only stood and resisted, Ukraine has repeatedly dealt serious blows to Russia's imperial ambitions. And here I would like also to say that Ukraine does not only speak about justice, but together with our partners, we are building concrete tools to ensure it. Like, for example, today the International Register of Damage in The Hague is already operational as the first element of the future compensation mechanism intended to provide redress for people, communities, and the state affected by the Russia's aggression. And our shared task is to make this mechanism a real pathway to restoring the rights of those who have suffered, who have actually been affected by the war. But all of this should not distract us from the central truth. Ukraine is paying an enormous human price for this resistance. And the fact that Ukraine is able to defend itself does not make this war any less brutal. It only shows the strength of our people. And this is important because too often the resilience can be mistaken for the stability. Strength can be mistaken for the absence of need. But Ukraine's ability to stand does not reduce the scale of suffering. It does not replace the need for the protection, and it does not diminish the responsibility of the international community. Ukraine wants peace more than everybody else because it is our houses, it is our heads that bombs and the missiles fall on every day. But such peace must be built on clear, on the clear foundations. It must guarantee security. It must ensure full accountability. And it must also leave no space for this aggression to come again and to be repeated. Because history has shown us and has taught us a very important lesson. Unpunished evil comes back. You cannot appease the aggressor. It simply doesn't work. It only makes it worse. So I'm very grateful for the freedom-loving people of the Republic of Lithuania, for the clear understanding of what is at stake at this war, for their firm and their principled stance, and for their comprehensive support. So I thank you all once again, and I wish us all a meaningful discussion. Ačiū labai. Slava Ukraini.
Thank you very much for these very important words. And now I would like to welcome Nida Grunskaine, Prosecutor General of Lithuania. You can say a few words for us. Thank you.
Gerbiami kolegos, svečiai, dalyviai, kalbėsiu lietuvių kalba, kadangi konferencija vyksta Vilniuje. Kreipiuosi į jūs šią išskirtinę mums visiems dieną, kai prieš 4 metus visas pasaulis sužinojo apie naujo brutalaus karo pradžią ir buvo priverstas susimastyti apie teisės viršenybės principų grįstos pasaulio tvarkos likimą, teisingumo ir žmogaus teisių sąvokų turinį, peržiūrėti tarptautinės bendruomenės atsakomybės ir pareigas. 4 metus vykstant kariniai agresijai prieš Ukrainą, kasdien fiksuojame naujus apšaudymus, sprogdinimus, nuo žemės paviršiaus nušluotus miestus, gyvybiškai svarbios infrastruktūros, sunaikinimus, prievartavimus, vaikų pagrobimus, civilių kankinimus ir nužudymus. Lietuva buvo viena pirmųjų valstybių teisinėmis priemonėmis reagavusios į plataus masto invaziją ir karo nusikaltimus Ukrainoje. Vadovaudamasi universalios jurisdikcijos principų, pradėjome ikiteisminį tyrimą dėl karo nusikaltimų ir nusikaltimų žmoniškumui. Nedelsiant inicijavome Eurojusto ir jo nacionalinių narių įsitraukimą. Kartu su kolegomis Ukrainoje ir Lenkijoje sudarėme jungtinę tyrimų grupę, kurios dabartinė sudėtis, bendrai priimti ir sėkmingai taikomi sprendimai nekartą buvo palydėti žodžiais. Pirmą kartą istorijoje. Nors pradžia nebuvo lengva, šiuo metu jungtinės tyrimo grupės nariai nuolat keičiasi duomenimis apie atitinkamus tyrimus, aptarė strategiją, prioritetus, derina tyrimo priemonės, bendradarbiauja su tarptautiniu baudžiamojo persekiojimo už agresiją, agresijos nusikaltimą prieš Ukrainą centru ir kitomis institucijomis. Šios dienos konferencijos akcentai – modernus technologiniai sprendimai. Tad negaliu nepaminėti to, kad jungtinės tyrimų grupės nariai vykdo sukurtą unikalią skaitmeninę nusikaltimų įrodymų duomenų saugojimo ir keitimosi bazę, kuri leidžia patikimai fiksuoti tyrimų duomenis ir užtikrinti jų įrodomąją vertę ateities byloms. Bei nuolat stiprina kompetencijas dirbant su atvirų šaltinių informacija, vaizdo medžiaga, geolokacija bei kitais skaitmeniniais duomenimis. Aktyvus ir sistemingas bendradarbiavimas su partneriais Ukrainoje leido Lietuvos prokurorams pareikšti įtarimus dėl režisieriaus Manto Kvedaravičiaus nužudimo, dėl civilių ir karo belaisvių kankinimo ir kalinimo Melitopolyje, dalyvauti atliekant proceso veiksmus Ukrainoje, bet tirti daugybę kitų šio išskirtinio apimtimi ir sudėtingumu ikiteisminių tyrimų epizodų. Negaliu nepaminėti vieno iš naujausių rezultatų. Praėjusiu metu rudenį Ukrainos generalinio prokuroro sprendimu Lietuvai perduotas Rusijos pilietis, kuris įtariamas karo nusikaltimais prieš civilius ir karo belaisvius, jų kankinimą, neteisėtą laisvės atėmimą ir Ženevos konvencijų bei karo papročių pažeidimus. Tai pirmas atvejis nuo Rusijos ginkluotos agresijos prieš Ukrainą pradžios, kai sulaikyta Rusijos ir karį Ukraina perdavė kitai valstybei baudžiamajam persekiojimui, vadovaujantis universalios jurisdikcijos principu. Tačiau visos kalbos apie išskirtinius karo nusikaltimų tyrimų rezultatus, pasiaukojantį prokurorų bei tyrėjų darbą, tarptautinio bendradarbiavimo ir kitokios pagalbos mastus nuo agresijos besiginančiai Ukrainai turi prasme tik tuo met, kai pagrindinis dėmuo juose išlieka karo nusikaltimų aukos. Kasdien negailestingai augančius karo nusikaltimų aukų skaičius privalome matyti ne kaip bejausmius statistinius duomenis, bet kaip žmonės, tokius pat kaip mes, mūsų artimieji draugai. Žmonės, kurių kadais taikus, saugus pasaulis staiga sugriuvo, kurie prarado gyvybę, vaikus, tėvus, ištisas šeimas, sveikatą, neteko namų, viso užgyvento gerbuvio, patyrė sunkiai suvokiamą fizinį ir dvasinį skausmą, bei liko su laiko neišgydoma trauma. Tačiau ir tai dar ne viskas. 21 amžiuje vykstantis karas Ukrainoje daugiau nei akivaizdžiai parodo, kad nuožmios kovos dabar vyksta ne tik pirmose fronto linijose, ne tik ant žemės ar ore, bet ir ten, kur regis nepraliejamas kraujas tiesioginė šių žodžių prasme. Žaibiškų greičių vykstanti technologinė pažanga, turėjusi tarnauti žmonijos labui, šiandien yra išnaudojama neteisėtoms agresorius tikslams ir verčia auką patirti ne tik tiesioginės nusikaltimo pasekmes bei žalą. Internetas, socialiniai tinklai, informaciniai portalai praplėtė karo lauką ir nesuvokiamų ribų, kuriame karo nusikaltimo aukas patiria nemažiau pavojingą ir žalojančią antrinę viktimizaciją. Dezinformacinės atakos prieš aukas, įvykdytų nusikaltimų neigimas, aukų ir jų liudijimų diskreditavimas nėra naujos kare naudojamos agresijos formos, tačiau skaitmeninių technologijų pažanga, dirbtinio intelekto galimybės suteikia agresoriui sunkiai suvokiamą griaunamąją galią. Tai dar labiau didina mūsų teisingumo institucijų atstovų atsakomybę. Norėdami išsaugoti teisės viršenybės principų grįstą pasaulio tvarką, kurioje būtų užtikrintas mūsų vaikų ir anūkų saugumas, šiandien turime daryti viską, kad kiekviena karo nusikaltimo auka būtų žinoma, išgirsta, jo liudijimai apsaugoti, o antrinė viktimizacija skaitmeninėje erdvėje efektyviai ir principingai stabdoma. Deja, tai nėra užduotis, kurios sprendimą galime rasti per vieną dieną. tačiau ieškodami jų kiekvieną dieną, dalindamiesi patirtimis bei įžvalgomis, tokius būtinai rasime. Todėl esu nuoširdžiai dėkinga šios konferencijos iniciatoriams, Mykolo Romerio universiteto ir ateities teisingumo tyrimo centrui už iniciatyvą ir pasiūlytą labai aktualią temą. Taip pat dėkoju visiems šios konferencijos pranešėjams už jų pranešimus apie aukų teisės, aukų psichologiją karo bei pokario laikotarpiu, už įžvalgas apie karo Ukrainoje pamokas aukų apsaugai ir kitomis temomis. Dėkoju Jums visiems už pasiryžimą savo žiniomis ir patirtimis prisidėti prie gilesnio aukos padėties supratimo ir veiksmingesnio jos teisių apsaugos stiprinimo. Esu įsitikinusi, kad tik nuoseklus tarptautinis bendradarbiavimas ir tvirtas įsipareigojimas apginti aukas ir jų teisės leidžia paversti teisingumą realybę, o ne deklaraciją. Dėkoju uždėmesį ir visiems linkiu prasmingos diskusijos, naujų įžvalgų ir praktinių sprendimų. Ačiū.
Thank you very much. And now we welcome our last esteemed guest, Dr. Egle Malinaskaine, Vice Rector for Research and Innovation at Mykolas Romeris University. Welcome.
Thank you. Your Excellency, distinguished guests, colleagues, and conference participants. As it was already mentioned in previous welcome speeches, today marks the 4 years since the full-scale war in Ukraine began. And it is very symbolic that today's conference on victimhood in times of hybrid crisis, AI, and digital transformation takes place here at Mykolas Romeris University exactly on this day. I hope that, first of all, this conference will not only serve as a platform for scholarly discussions, but also as a moment to pause, reflect, and reaffirm our commitment to justice, solidarity, and the protection of those affected by crisis. This conference today gathers a distinguished group of scholars, practitioners, and experts from across Europe and beyond. And it will go to deep examination of how the idea of victimhood is evolving, not only for individuals, but also for organizations and communities that suffer harm during hybrid crisis and rapid digital change. It will help us identify lessons learned, pinpoint remaining gaps, and consider how to address them. The conference will explore how criminal justice systems can better consider victims' needs, use digital tools to improve access to justice, and strengthen support mechanisms to those affected. By connecting research and practice, the conference aims to promote victim-centered justice, support societal healing, and encourage accountability and sustainable reforms. Over the course of today's discussion, you will hear from leading experts in law, criminology, international relations, digital technologies, and human rights. I hope the diverse perspectives will inspire new insights and collaborative solutions to the challenges we face in our region and probably all around the globe. On behalf of Mykolas Romeris University, I would like to thank the ambassador and the general prosecutor of being with us today and engaging together into these discussions. And also I would like to say tremendous thanks, gratitude for the Mykolas Romeris University team, for Katarina, for her son, for Monica Rogers, for Dovilė Sagatienė, and for your international partners from Ukraine universities, Finland, and UK. Thank you for your passion in this really very sensitive and meaningful research, and for making this research probably have an impact to the practice. Thank you, and wish you a very good event today.
Thank you very much. Thank you very much, esteemed speakers, for your words and your encouragement of our research. And now I would like to start our conference, and I'd like to invite our first speaker, Dr. Mikhailo Shepitko from Yaroslav Mudry National Law University in Ukraine, with his speech, Victims' Rights and Current Challenges, War in Ukraine and Other Conflicts. So we each have 20 minutes. I can tell you when you have close to the end, I'll just maybe wave my hand or just open and say you have 2 minutes. Okay?
Okay.
All right, thank you. And good luck.
Thank you so much. Just a moment. It's necessary to try how it's work. It doesn't work. So Maybe. No. Just a moment. Can you help me? This one?
This is working. We have to find. This is your presentation.
Yep.
Oh, okay. So it wasn't. Guess it wasn't.
Oh, thank you so much. Dear colleagues, it's great to see you today, and it's not coincident that we are together this day because it's 4 years of Russian aggression against Ukraine, and topic of our conference connected with victims, I think it's key question that we must discuss not only during the aggression, but during all period during the conflict and after the conflict. And because of this, we are here. How to support victims, how to defend them, how to survive during this period. And this period, 4 years, it's very big. It's a time when persons were refugees, and somebody's are refugees in Lithuania, in Poland, in Ukraine, in other countries. And first of all, I would like to thank you, Lithuania and Lithuanian people, for this support during this whole period, legal assistance during cooperation with in international groups of investigations, during the armed support with weapon, because it's also a key question during this period. But today, topic of my speech will be connected with victims' rights and current challenges, war in Ukraine and other conflicts, because this aggression in history of our planet, not the first. The definition of laws and customs of war and the status of victims of armed conflicts has a long history. Codification of IHL, International Humanitarian Law, is related to the activity of the foundation of the International Committee of Red Cross after the famous Battle of Solferino, Italy, when the Swiss businessman Henri Dunant was forced to organize the burial of the dead soldiers and provide medical, psychological, and other assistance to the wounded soldiers. Same for his initiative, and the Swiss government and conference was held in 1863. And the International Committee of the Red Cross was created, which recognized a neutral and independent organized whose exclusively humanitarian goals and objectives are to protect the life and dignity of victims of war and situation to violence in the country and to provide assistance to them. One of the merits of this organization is the regulation of the laws and customs of war, fair as well as the interpretation. And after the Second World War, international law based on previous international relations, international law and practice of it, the experience of the global conflict and its result in the form of the Nuremberg and Tokyo tribunals in accordance with the charters, made it possible to adopt the Geneva Convention, which were aimed at protecting the wounded and sick in armed forces in the field, the wounded, sick, and shipwrecked at sea, prisoners of war, the civilian persons in time of war. The additional protocols to the Geneva Conventions, as well as other conventions, mostly only supplement the protection of the rights of victims during war. In fact, we are talking about a certain classification of victims of armed conflicts, as well as the protection of their minimum human rights. Under the Geneva Convention 1949, the Hague Convention for the Protection of Cultural Property in the Event of Armed Conflict 1954, and the customs of international humanitarian law, certain victims of armed conflicts received special protection. And you can see this classification. The establishment of international courts and tribunals for the former Yugoslavia and Rwanda, and the establishment of a number of ad hoc hybrid courts not only created important cases, but made it possible to clarify and comment on the customs of international humanitarian law, but also created the conditions for the establishment of the International Criminal Court in The Hague. The ICC is currently conducting a preliminary examination with 3 situations, including Republic of Lithuania, and 17 investigations of other countries, including Ukraine, and also has or had 34 cases in history of ICC. Lithuania's referral alleged if we speak about Lithuania, beginning in April 2020 and from at least 1st May 2020, partly and going to the present today, and continuing crimes against humanity. It's also one of the questions that ICC must answer for us. It should be recognized that the real protection of victims' rights in national and international courts is mostly an exception to the rule and can rather only be demonstrative. An important development in the protection of victims' rights in the world was the adoption and implementation in the Rome Statute of the ICC and the creation of the practice of protection victims' rights by ICC. The Rome Statute of the ICC is a well-known international legal act that mostly fully classified the core international crimes and created a fully operational mechanism for bringing individuals to criminal responsibility for their commission. The ICC rules of procedure and evidence also provide a fairly simple definition of the victim as natural persons who have suffered harm as a result of the commission of any crime within the jurisdiction of the court, as well as organizations or institutions that have sustained direct harm to any of their property, which is dedicated to religion, education, art of science, or charitable purposes, and to their historic monuments, hospitals, and other places and objects for humanitarian purpose. The Rome Statutes of the ICC paid attention, first of all, to ensuring the safety of victims and witnesses. However, the ICC regulation already states a greater number of rights regarding the participation in the process, the provision of evidence, and right to reparation. It is clear that the most important thing for the participation of victims in the process is ensuring their safety, as well as a real prospect of restoring their rights and reparation. For this purpose, the court has established a trust fund for reparation to victims. At the same time, it should be noted that this mechanism is rather only the selected victims. In individual ICC trials, and such reparation are demonstrative and remain an ideal model, not typical, ideal model. The main burden of protection the rights of victims is carried out precisely within the framework of national jurisdiction. The United Nations Refugee Agency in 2024 is demonstrated that the number of people forced to flee persecution, conflict, violence, human rights violation, and even seriously distributed public order rose, reaching a record 123 million. At the same time, slightly more than 1/3 of all forcibly displaced people globally were from Sudanese, Syrian, Afghan, Ukrainian. In Ukraine, this agency, United National Refugee Agency, fixed something like 9 million people in 2024. The context of forced displacement becomes important in this regard. Particular attention is paid to the situation of armed conflicts, including international ones. The number of deaths, primarily of the civilian population, as the least protected in various conflicts, shows the cruelty, hatred, spread by propaganda, public calls for physical destruction, and the growing use of the media. The number of deaths, injuries, and those who have lost their advantages is measured in millions, especially in such conflicts. Is it possible in such case to fully restore the rights of the victims during or after the conflicts? Probably no. But it's realistic to make maximum efforts to restore them and take real actions with a view to preventing such a conflicts from happening. I believe in it. Therefore, unpunished evil leaves an invitation to new armed conflicts and their new numerous victims. One of the largest armed conflicts in Europe is considered to be the Russian full-scale aggression from 2022 to 2026. For 6 years, the Prosecutor General Office in Ukraine registered criminal proceedings on the ground of war crimes. Today we heard our ambassador, and she also told about more than 200,000 registered, documented war crimes in Ukraine. But you can see also other crimes that registered in Ukraine: crimes against humanity, crimes of aggression, more than 100 crimes, genocide, 35 crimes, and ecocide, 24 crimes. At the same time, it should be noted that the commission of these core international crimes was documented even earlier, starting with the annexation of the Crimea, the city of Sebastopol, as well as certain parts of Luhansk and Donetsk region, 2014. It was from the period that national courts began to pass verdicts violation of the laws and custom of war crimes. Ukraine only partially implemented the Rome status of the ICC on August 21st, 2024, which made it possible to use its norms as part of its own legislation. This also affected the conflicts of individual norms of substantive and procedural criminal legislation. In particular, the Criminal Code of Ukraine was supplemented with crimes against humanity, war crimes in new norm of criminal code, and genocide. The Criminal Procedure Code of Ukraine also received a separate section, special regime of pretrial investigation, trial under martial law, and the features of cooperation with International Criminal Court. However, the amendment don't affect the status or rights of victims. The most important rights of victims during armed conflict remain: the rights, not the obligation, to provide testimony and evidence in criminal proceeding, ensuring the protection of such persons. This is what makes it possible to obtain testimony and evidence of the commission of international crimes, and receiving reparation. This can in some way restore the violated rights and further motivate, it's a question of motivation them, to participate in the public process. The public interest in the administration of justice in such national and international trials places the suspect and the accused as the central figure, at the expense of which the rights of victims take a backseat. The right of the victim to provide testimony and evidence in criminal proceedings is granted under the fear of criminal liability for crimes against justice, and the risks of revenge from the aggressor must be ensured by security measures during the administration of justice. The central and desirable place of the victim among the right of victims is reparation, which cannot be fully implemented before or during the administration of justice, in my humble opinion. In this context, technical assistance in combating international crimes and documenting such crimes is important. This assistance can be critically important not only for starting a pre-trial investigation in Ukraine, but also for providing the necessary evidence for the work of international courts. An example of such activity is the coalition Ukraine 5 AM, which was formed by 16 Ukrainian human rights organizations. And they documented war crimes, crimes against humanity, and the violation of human rights, first of all, in the beginning of Russian aggression. The Sunflowers project has taken a similar function for documenting war crimes committed in Ukraine abroad, and we speak about activity of non-governmental organization. It's also important, and communication between Ministry of Interior, General Prosecutor's Office is also important of them because they have information from victims directly from different countries. And Sunflowers project is one example of it. In Ukraine, there is not special fund created with a framework of criminal proceedings that could ensure the right to reparation for victims. A traditional weak point is the provision of protection for victims in criminal proceedings. It seems that providing such protection during war is illusory due to the presence of serious spy network of the enemy army in Ukraine and Europe. Successful in this context of the slow administration of justice in national and international courts is this creation of digital mechanism for compensation, reparation for damage caused by the aggressor during the war in Ukraine. I could demonstrate Ukrainian experience because in Ukraine, in the beginning of war, was prepared Ye-Відновлення or e-restoration, is a state assistance program for owners or damaged and destroyed housing. It allows for online or on-site contact with official bodies by reporting data about damaged object, providing photos and description of the damage. After that, a special commission is created to assess the damages. For damaged properties, the payment will be credited for the restoration cut. And you can see more than 200, I think this period, 250,000 object damaged, and people received reparation for this. It's not certainly full price, it's not administration of justice, but it's real support of our people. And thank you for your attention. Thank you so much. And if you have a question, I think in the end of the panel,
Yes,
we will have
a panel discussion at the end, so keep your questions for now, and we will address it in the end of the session. Thank you, Mykolas. Thank you for keeping time. And our next speaker is Associate Professor Dr. Katerina Latish from Mykolas Romeris University with lessons from the Ukrainian war for the protection of victims. Welcome.
Hello to everyone, and thank you for coming, and thank you so much for General Prosecutor and Vice Rector for this opportunity to speak and that you come. And our project is not only about Ukraine, of course, but particularly, and today we have anniversary for 4 years from the full-scale invasion. And we concentrate not only on Ukraine, but specifically, and we have also in our project historians, and but in my today's presentation, of course, I will concentrate more on Ukraine and the lessons that we learn from the experience nowadays. And I will not talk only about the war, but I will talk in the broader perspective, in the perspective of hybrid crisis, because you can see that we have not only war in the military way, but also kind of cyber attacks, and also we see in Lithuania for the several years that we have cyber attacks against critical infrastructure, against some governmental institutions, and this is also a part of the hybrid crisis that we have nowadays. And unfortunately, not only in Lithuania or in Ukraine, but in a broader context. So we also need to see how we can address these kind of challenges. And so for that reason, I consider in my presentation from three perspectives: from the perspective of cyber attacks, and from the perspective of influence of AI, because all of us already knew about AI, somebody using it in an ethic way, of course, but also AI helped a lot our law enforcement bodies to enhance their investigations, for example, to analyze big data, especially when we are talking about propaganda and when we need to find keywords and not to listen to the whole amount of videos that we have on YouTube or we have in the news, and AI can help us to find it, the keywords, and then specifically use humans to analyze it and to do other legal work. But of course, when we are talking about legal stuff, it means that we need to have legal requirements for that. And then we have a lot of questions from our judges, how we can use AI in this specific procedure. And also, when we are, have interrogations with victims, for example, maybe we can also kind of find the way how to digitalize this process, and I will talk about it later. And of course about military, about war, what we have now in Ukraine, and I will share the lessons that we learn that can be useful for prosecutors, that can be useful for academics, and for further research, because unfortunately in this framework we can see that we have legal framework and which is not address the practice needs, and practice go forward, but still as long as it come to the courts, we need to admit also legal requirements. And what is the most maybe familiar for you, it's about deep fakes, because also you knew that when the full-scale invasion in Ukraine started, it's not only about military stuff, yes, it's also about hybrid threats. And we can see that the video, deep fake video with our president Zelensky was produced, deep fake video that was shared widely, kind of to tell people that we already need to do something. So it's also very dangerous, and we need also to see how to address this kind of things. But again, as I said previously, it's not only about the war, but also we can see that actually even our photos can use or videos with AI to kind of to share some sexual abuse materials, for example, for child sexual abuse materials, Grok and that Elon Musk recently produced. So basically, we are not in a safe zone now, unfortunately, and this is also something that we need to think. This is video which about which I was talking, so this is something tangible that we can see nowadays. So what we can say shortly about lessons that we learn. Professor Mykolas Romeris previously in his presentation addressed how the ICC, how in the Rome Statute, it's addressed who is the victim. Because usually we used that victim is individual, but not really. Really, we can see that companies and organizations, they're also victims. And what we see in Ukraine, that when individuals struggling, then they become victim. It's a big struggle to receive procedural status as a victim. Not all of them can receive it, unfortunately, due to some procedural constraints and due to scale. But also when we are talking about companies, business organizations, even governmental structures. So for example, for individuals, we have the procedure how they can proceed if they have some harm, damage, and so on. But for legal entities, we don't have it. So, but this is also something that we need to address with the procedural rights. The second problem is the access to testimonies, because we know that a victim cannot be every time on the territory where the law enforcement bodies investigate this specific crime. It could be an occupied territory when we don't have access to victim, when we don't have access to the territory, and of course the victim can be very much afraid to give testimonies, because then next day the enemy soldiers came to him or her and or to their relatives. So this is also something that we learn from the experience in Ukraine. And of course, sexual violence, we also know, and I think that from the presentation during the second panel from Yulia, we will hear how rape can be used as a tool. And also we know from Lithuanian perspective, from history, then during Second World War, there was also the rape was using as a weapon, but unfortunately it was not used to talk about that. But from archives, now we can see that we have these tangible documents that can also give us the light into this problem. But the same we can see also in Ukraine and other conflicts, and Yulia will tell you in other conflicts how it's used. And again, the victim can travel abroad, yeah, to find the asylum, to find the way as a refugee, and Lithuania is one of the biggest supporter of Ukrainian refugees. Then we need to find how we can have access to this victim. Okay, we can take the testimonies, and Lithuania was also, I think, that proposed a very interesting way when the refugee came first to the migration department. They also fill in the application whether they were witness or they were the victim, and then the prosecutor's office or the policeman can contact this victim. But then again, as long as we are lawyers, and we need that, then this testimonies will be good enough for the court, and we don't traumatize this person with multi-interrogations. So this is also something that we need to address, and I will tell you later how we can also do that. Another problem is when the testimonies took from by the NGOs, and in the previous presentation we have heard about Sunflowers project. We also know that a lot of NGOs, international NGOs, also respectable one, tried to get these testimonies, but again, many subjects collect this information, and what come next, because anyway it's important, of course, for victims it's very important to be heard, but anyway the outcome in the court should come. And the last point, of course, not least that online investigation measures, because it's the war in Ukraine is still ongoing. It's very dangerous to go over there. And the second thing is lack of budget, because I think that it's the prosecutors and law enforcement body, they don't have separate budget to go there. But at the same time, a lot of digital tools can be used to receive the access to the territory. Here, just shortly, because I don't think that I have a lot of time to speak, I addressed different options for the justice process. So basically, it's national courts, but this is how architecture looks like. Not only in Ukraine, but in general. So basically, the first stage is national courts, but usually some of them situated on occupied territories, have destroyed facilities, lack of judges. So basically, this is the task of national system. But when we are talking about crisis, of course, most probably it's not enough. Then we have ICC, International Criminal Court in The Hague, but they have limited jurisdiction. For example, for crime of aggression, they don't have it. And then we need also to find the way how to address this gap. So the special tribunal, and now you know that the work is ongoing with regard to that. Special tribunal is created on the framework of Council of Europe, because it also took a lot of time to find the way that it will be respectable, that many countries recognize the jurisdiction of this special tribunal, and unfortunately it was impossible to do it on the framework of the UN for visible reasons, because of Russian and who can use veto and other subjects. And universal jurisdiction, about which we shortly have heard from the speech of the General Prosecutor of Lithuania. This is when, for example, in Lithuania, Lithuanian prosecutor's office can investigate crimes they committed in Ukraine. And in this slide, you can see how many countries concentrated only on crimes on Ukraine in the framework of universal jurisdiction. It's more than 20 countries who are doing that. And the biggest subject on that is Joint Investigation Team, which was initiated by Lithuania, Poland, Ukraine, and Latvia, Estonia, Slovakia, Romania. And first in the history, ICC joined, and Eurojust. So this is also a very big contribution, and I think that very unique if we compare with other conflicts. With regard to crimes in Ukraine, short overview with numbers. I will not go through it because you already most probably knew this huge number. I will only stopped on the AI and the examples how AI trying to use, for example, in forensic science expertise. But again, I need to say that we don't have a sufficient legal framework, but we try to use in a way that the legal framework is technically neutral. So we don't have restrictions, we don't have a specific legal norm that prohibited to use it, but at the same time we need to admit the legal requirements and where we took this data and all other procedural things. On this slide I put what kind of challenges we have with regard to that, and how AI can be used as tool. Again, I'm not saying that AI can investigate the crime, okay? I'm not saying that it can be used in a way how do you want to use it, no. But AI can be used as a tool, but again, to admit all legal requirements, like we are using Word or Excel for some simple task. So this is the first example with regard to how AI was used in the forensic science expertise. We had article that was published together with Professor Shepitko that you have heard before me. So we found this video, most probably you have seen it on YouTube. when one of the soldiers, he was the prisoner, he was killed on this video after he said Slava Ukraini. And we need to identify this person. So how we can identify if we just have this video on YouTube and the quality of this video is not very good. So what Ukrainian forensic science experts did, they use AI, but not for analyzing, but in this specific case, but to enhance quality of the picture, to see the specific features, and you can see with numbers how they kind of try to compare. So it's not, it was not used as an expert to say whether it was this person or not. So again, it was used as a tool. Or for example, it can be used when we need to analyze satellite images. Of course, I'm not saying that this is panacea and it can be did very fast. Technology is moving forward every day, but this is also something that you can use. For example, over here on the left side, you can see the satellite images, and then you can see on the second part on the right side, you can see the pictures from the videos on the side from some buildings of locals. So you can see how you can also to compare and to read. Also, you can use different databases to analyze, and now I can say that in Ukraine you can see the difference in court practice before the full-scale invasion and after, how they interpret this kind of open source information. So just to conclude, we can say that it's crucial to have interdisciplinary efforts, not only legals, but also IT staff who can help to find more evidence, more information that can potentially become evidence through the online, through the internet. Of course, we need to find legal frameworks to ensure the admissibility of this evidence in the court and when we are sharing between different countries. And this we can use mutual assistance, but at the same time a joint investigation team framework for this reason, and again to see the best practices from other countries, how they are doing that. As I said about historical precedents, I will not go through it, but this is also something that we addressed in our project because we have distinguished historians on board, and this is also something that showing the attitude of victim and why for victims it's very important to have justice, even if it happened during the Second World War or as in Lithuania during occupation of the Soviet Union, but also before, as it was in Ukraine with Holodomor famine. So basically this is what I want to address, and final remarks again. We can say that if justice delayed, justice denied. For me personally, and what we learned from our project, it's not really like this, because again, we are analyzing from historical perspective. We interviewed victims of Soviet crimes, and we can say that anyway, it's important to have even justice, even if it passed quite a long time, because we need to advance international accountability and to create no safe haven for perpetrators that they can hide or they can travel, as for example Putin, to Mongolia or to other countries, and not to be not to have justice in this framework. Thank you for your attention, and looking forward to our panel discussion after all our first presenters. Thank you.
Thank you, Katerina. It was a very interesting presentation, and I've learned very much new things. Now we'll go on to Brendan Humphreys, Dr. Brendan Humphreys from University of Helsinki, and he'll be presenting on Between Acknowledgement and Denial, the Croatian/Serbian Victimhood Olympics. Welcome, Brendan.
Thank you. I can't find my presentation immediately. Could somebody help? Yes. make it still.
Use keyboard and mouse.
Mm.
Now, presentations are this one. F5.
How can we get this full screen? Can we make it full screen? Yes, looks better. And I can. Yes, distinguished guests, ladies and gentlemen, it's so nice to see so many of you here, and welcome to everybody who's participating online as well. I'm going to shift the focus now for the next 20 minutes, and I hope it will be 20. I'm a historian, I'm a political historian. My topic will deal with some specifics of Balkan history, but I don't want to get bogged down on that. You're not Balkan historians. What I think would be more useful for the project generally if I speak a little more abstractly, a little more generally about some key concepts and then move towards the more detailed aspects. But we have a problem in confronting victimhood with the individual and the collective. I'm more interested in the ideas of collective victimhood. The problem is the collective large and flexible enough to contain many individual subjectivities? All those different individual life stories, do they amount to a collective? And this is as true as collective victimhood as it would be of a very big topic at the moment for the last 30 years, collective memory, or collective identities, which is a currently very large and ongoing topic. The problem of collective memory, of course, was once put by a French satirist, is that, you know, in his dictionary he wrote, Nazism dead and buried in 1945, an excellent year for Red Bordeaux. So somebody's individual memory can not recall 1945 as the year of catastrophe in European history, but rather the year in which there was, after all, very good red wine. And I've left deliberately an image of Marcel Proust there, just to show the subjectivity of memory. I will speak a little bit about nationalism because I'm a nationalism scholar. To quote Billings' banal nationalism, there seems to be something psychological about an identity, but the theories of psychology are often unable to explain what this psychological element is. There does not seem to be a particular psychological state which can be defined as an identity. An identity is not a thing. It is short-lived, shorthand description of ways of talking about self-community, again, the individual and the collective. And he speaks about a dialectic of remembering and forgetting. I'll keep this as a keynote, said to sustain national identity. So this identity evolves in a dialect of inwardness and outwardness. These identities are never set. They are movable objects. To dwell a little bit on the individual, not too much. I mean, it's long associated with individual psychology, particularly that of Erik Erikson, the man who coined the phrase identity crisis. He was the first theoretician of identity. And his theory of psychological social development firmly locates identity within the individual psychology. You do not look at that in any great detail. But then if we move up to the collective, and collective is now associated with a term identity politics, which you hear a great deal about. It's usually used as a very pejorative term. I think it's largely misunderstood. All politics is identity politics. It's just hegemonic politics is not even noticed because it does not have to speak in terms of identity. White men run the world. They don't speak about themselves as white men. It's as simple as that, I would say. It's very controversial. Again, we come with this problem. How do we move from individual psychology to group activity? And group activity, as we know it, is politics. To posit the idea of collective victimhood, it becomes rather problematic. Can a person be a secondary victim or even a tertiary victim? That you feel you're a historical victim of something that happened to your grandparents' generation. There can even be a vicarious, that is, you identify, connect yourself with victimhood, or even the idea of a surrogate victim. Now I'm going to quote from Dominic Lecapra's study, Trauma, Writing History. He's commenting on Claude Lanzmann's landmark documentary on the Holocaust, Shoah. There is in Lanzmann a fascination with the victim, in the older sense of fascinatio, and almost the desire to identify with the experience of the victim because Landsman himself was not a victim of the Shoah, yet somehow feels he should have been a victim, that he should have been part of this process. It is rather unusual circumstance. If I can continue on the Holocaust theme, to quote Peter Novik's Holocaust and Collective Memory, he speaks about the ritual of visiting Holocaust museums in the United States, of which there are a great many. It's strange that the Holocaust took place in Europe, not in the United States, but there's over 70 Holocaust museums there. In any case, the typical confrontation with the Holocaust for the visitors to the American Holocaust museums and in burgeoning curricula, meaning in universities, does not incline us to think of ourselves as potential victimizers. We're not the perpetrators, of course, rather the opposite. It is an article of faith in these encounters that one should show the identity with the victims, thus acquiring what he calls the warm glow of virtue that such vicarious identification brings. Handing out victim identity cards to museum visitors is the most dramatic example of this, but only one. So a question arises: if you can be a surrogate victim or a vicarious victim with this warm glow of virtue, can you be a vicarious perpetrator? I'll leave that hanging in the air. Does somehow make you responsible for your grandfather's crimes? If we can feel we are traumatized by what happened to our grandparents in the 1940s, is it not equally logically, at least logically, if not morally the same, that we are morally responsible for things that had happened back then, for what our grandfathers did? Nationalist sentiment, well, nationalist sentiment is odd because it may articulate itself as chauvinism, as arrogance, as self-congratulation, we won, or as wounded pride, as humiliation, shame, superiority, or inferiority, or simply pride in one's own place and people, which is reasonable enough. Yet even this list is not so simple, as there are some likely and even incongruous pairings. Wounded pride or humiliation might manifest themselves through some sort of necessary psychological or emotional compensation process as the opposite, as chauvinism, or even as arrogance. A feeling of inferiority, which is very common among conquered or colonized peoples, might attempt to fit on a mask of superiority and pride through some form of special pleading. It is a double burden. First of all, the feeling of inferiority that you have, and secondly, the shame that you cannot admit to the inferiority. And I think from that point of view, George Bernard Shaw was very correct when he divided nationalism into healthy and sick nationalism. That, confident nationalism does not have to speak about itself. Wounded nationalism, compensatory nationalism, is like an ill person constantly talking about his illness. I think what he had in mind at the time he was writing, of course, he was an Irish-born British playwright. He was talking about the wounded pride of the Celtic nations rather than the confidence of the British Empire, which was then the biggest political entity in the world. Some recent perspectives on this. There's been an interesting study of national indifference. I have a very bright PhD student working on this at the moment. And there's what recently Lee Hwan Lim speaks about victimhood nationalism. He's a very articulate Korean scholar who's worked actually in many parts of Europe. We had the pleasure of speaking with him in Krakow some years ago. And he speaks about the epistemological focus of the book lies in meta-history that conducts and represents victimhood nationalism via that interaction of history and memory. Memory is not an empirical substitute for documentation. Memory is, again, so subjective, but a vital apparatus for the epistemological politics representing the past. We prefer memory to hard documented facts, the kind of collective, identity building of this. Let's speak a little about perpetrators. There's sometimes been theorized as at various levels. You have the actual person doing the killing on the ground, the low-level killer, and then you have the architects or the organizers, which would be, of course, the political elites who organize these things, often who never take part in bloodshed themselves. We can oppose perpetrators typically as, first of all, as victims, or as more ambiguous figures such as bystanders or as witnesses. The motives of individual perpetrators become very, very complex indeed. I'm just quoting from Michael Mann's study. We have after all ideological killers who believe in the righteousness of their murderous cleansing, bigoted killers who share the prejudice of their social environment, violent killers who experience just the release of it, fearful killers who kill out of fear, careerists who work for organizations involved in atrocities to participate further their career interests, materialist killers, people who are motivated by economic gain, and I counted this actually doing some work on the Bosnian War. Disciplined killers who killed to conform to directives. Already you're seeing German troops from the Wehrmacht. Comradely killers who conform to as part of a peer group. And bureaucratic killers who are situated within bureaucracies and motivated by habitual obedience. Type of figure that we've seen studied a great deal in sociology, the conformist. I'd like to speak a little bit about denial. The most, I think, useful theoretician of denial was Stanley Cohen in his book States of Denial. His guiding definition of denial, and I mean this will be something that all of you legal scholars will see going forward when people are prosecuted for the war crimes taking place in Ukraine, will be numerous forms of denial will be floated out. Again, some of this work was evident from the prosecutions of Yugoslavia. What he calls it is denial is the need to be innocent of a troubling recognition, of simultaneously knowing and not knowing. He identifies three forms of denial. One, literal denial. It didn't happen. We did not bomb that city. Interpreted denial. When you find out the city was bombed, yes, the city was bombed, but it's not what you think it was. And then it might move on to implicitory denial. Yeah, the city was bombed. That was unfortunate. But in point of fact, we had to bomb the city, and it was fully justified. So what happens is justified. And as he points out, sometimes these appear in a visible sequence. If one has not worked, you move on to the second one, you move on to the third one. I think in the ongoing war in Gaza, we have seen this sequence of excuses floated out. I would now go to the opposite of denial, acknowledgement. I'm quoting from a very insightful, very profound book, Primo Levi's The Drowned and the Saved, the last book he wrote, in fact. He was, of course, himself a Holocaust survivor and a very, very articulate one. He said, almost all survivors, orally or in the written memoirs, remember a dream which frequently recurred the night of their imprisonment. Varied in its detail, but uniform in its substance. That is, they had returned home and with passion and relief were describing their past sufferings, addressed themselves to a loved one, but they were not believed. Indeed, they were not even listened to, and in the most typical and the cruelest form, the listener, the interlocutor, turned and left in silence. Plainly, acknowledgement for our suffering is a profound emotional and psychological need, as I think is attested to very well from this text. The problem is then acknowledgement by whom? We could say that successive Turkish governments have never acknowledged the massacre of Armenians in 1915. Yet the massacres are generally acknowledged by outside forces, by third parties, if you want to say witnesses perhaps. So there is outsider acknowledgement in this particular case, but there is not perpetrator acknowledgement, or at least vicarious perpetrator acknowledgement. There cannot be any of these perpetrators alive anymore. The obvious contrast is, of course, is post-World War Europe. Post-war federal, that is West German governments, generally acknowledge a responsibility for the Holocaust. It took, for instance, decades for the Russians to eventually admit the recognition of the Katyn massacre in Poland. That was denial that's most basic. To speak a little bit about now the details of the Serbian, so shall we say, victimhood nationalism. Serbian historical suffering is, I think, not widely recognized. Serbs certainly, and informed parties, historians, and others know there was a genocidal campaign waged against Serbs during the Second World War. This was a campaign led by the independent state of Croatia, the Ustasha movement, and in Germany directly occupied parts of Serbia, and was a site of a brutal policy of retribution. 100 Serbian civilians were killed for every German soldier killed. 50 civilian kills for every German soldier injured. A horrible toll on the civilians. And if one goes back to the First World War, Serbia's losses were overwhelmingly higher than any of the other allies. the major combatants, Britain, France, Germany, lost between 1 and 3% of their populations, overwhelmingly young men. Serbia lost something like nearly 50% of its population by some counts. 60% of its men were all killed in the war. And the country underwent the rather brutal dual Austrian and Bulgarian occupation, which seemed to anticipate the horrors of the 1940s. There was very few actual occupations during the First World War, very much unlike the Second World War. But one of them that did take place was in Serbia. This recent Serbian-made film, Dara of Jasenovac, has brought a lot of this back into contemporary consciousness. So I use the phrase oppression Olympics. In a review of this particular movie, the tragedy of Jasenovac, which was the largest camp, it was both a concentration camp and an execution camp, which was run by the Croatian collaborationists. The tragedy of Jasenovac has now been used as a political football in the ongoing game of oppression Olympics between Serbia and Croatia, with both countries trying to outdo each other in regards to who has suffered the greatest amount of injustice throughout their history. Myth-making or genocidal cultures, one particularly polemical, not a very scholarly work about this, the Serbian myth of Jasenovac, takes the kind of Croatianist nationalist perspective. The Jasenovac myth was crucial for the assertion that the Croatian people are genocidal. This was exactly the stimulus for the Serbs to commit genocide against the Croats in the war in Croatia and in Bosnia and Herzegovina. So there's a kind of flipping of allegation here. And to quote a slightly more serious work by Banavir Razulevic's Heavenly Serbia from Myth to Genocide, he makes the accusation again that Serbs are a genocidal culture. It's something inherent to Serbs, which, of course, the counter-allegation is something inherent to Croats. That book has actually been translated into several languages, and I've heard some scholars take it seriously. And to me, it's just one-sided special pleading and nationalist propaganda. One incident of the Second World War, which has become a kind of a counter-narrative to the Serbian narrative of Jasenovac, is the Bleiburg commemoration. Bleiburg is actually in Austria. This was at the end of the war when a lot of the Ustaša leaders, that is, the Croatians, left along with Chetniks because a lot of Serbs collaborated with the Germans in the Second World War, which they tend to forget about. And some of the Slovene Home Guard, who were also collaborationists. These troops very controversially tried to surrender to the British, but they were actually sent back to Tito's partisans, knowing very well they were executed, and they were executed in masses. The numbers still questioned, but all the numbers that come out of Yugoslav history are questioned. People try and inflate them, people try and reduce them depending on their national bias or perspective. So Bleiburg has become a post-war symbol of Croats' suffering, and it still remains somewhat controversial. Some journalists spoke about it as being a gathering of nuns and neo-Nazis, which sounds like
Two minutes.
Sounds like a 1970s exploitation movie. But just one quotation now. In 1995, a speaker of the Croatian parliament, Zbor, spoke of the Holocaust of the Croatian martyrs who sacrificed their lives for the ideal of Croatian statehood. Some of them were innocent, but many of them were literally fascists who had carried out a genocidal campaign. But they've been elevated into this new martyrology. So examining the field of contested victimhood claims that come from Yugoslavia's complex and Second World War, it said that everyone who was trying to find this ideal victim and this projection of memory, some victims disappeared completely while others would rotate at the top position. These are just two examples of the two most famous post-war show trials, one of Archbishop Stipanic, the Archbishop of Zagreb, who was put under house arrest, and Draža Mihailović, the Serbian Chetnik leader, who was then executed. Responses to collective violence. Marta Mino speaks in Between Vengeance and Forgiveness of the rhetorics of history, truth, theology, the idea of forgiveness, justice, very much the department here, punishment, compensation, deterrence, therapy, healing, art, commemoration, disturbance, education. However, she says none of these is adequate. There has to be a combination of these factors. And I think I can just finally reach a conclusion in time. Knowledge, I'm particularly interested in historical knowledge of finding out the most accurate picture we have of the past as objectively as we can, does not necessarily lead to acknowledgement of past suffering, but there can be no acknowledgement without knowledge. Historians have a role in this, but ultimately there must be a political will to acknowledge the past crimes, and only that will break the cycle of violence. And I will end by a quotation of Archbishop Tutu, who ran a course of marvelously successful, very courageous, difficult process, the Truth and Reconciliation Committee. It is not about patting one another on the back or turning a blind eye to the wrong. True reconciliation exposes the awfulness, the abuse, the hurt, the truth. So with that, I will thank you and move on to our next speaker.
Thank you very much. Thank you. So our next speaker is online, Dr. Mykolas Sadowski with Pirates, Laws Victims or Laws Victors from University of Strathclyde in the UK.
Yes, hello, and let me just see if I can share my screen. Okay, let's see if that works. Okay, can you see my slides now?
No. Just
Okay.
1 minute, we'll try to figure it out on our end here.
Yeah, I'm definitely sharing my screen here.
Now we can see it.
I think there it is. Perfect. Thank you so much. All right. Hello, everyone, and thank you for this wonderful introduction and invitation to participate in this great conference, all the more so on this particular date. As you can see, my topic will be slightly different than those of the others. It's an excerpt from my upcoming book about piracy in law, which is coming out with Routledge at the end of this year. And to be fair, this particular perspective on the book came and on my research topic came only through my work on this project, on the Victimhood project. I thought it would be perhaps a good idea to include this particular perspective, because as many of the previous speakers have noted, when we speak about victimhood, we often think about particular individuals, but in reality, victimhood is created also among particular communities and at particular historical times, and sometimes it can come back within the same groups, and I think that's in a way a little bit what today's presentation is about. First things first, why piracy? Sorry, I'm a legal theoretician first and foremost, but I started working on piracy a few years ago, exactly from the legal theoretical perspective, because both back in the day and in the present day, pirates represent a particular example of, and here researchers use different denominations. Some call them a subculture, some call them a counterculture. Others see it as a particular culture within law, even. Without maybe deciding this right now, let me say that the main perspective I use in my book is to see pirate through these three images that we have of them in our collective memory. And this is perception of pirates either as lawless adventurers or as freedom seekers, or perhaps as treasure hunters. So these three images stem from what is called right now the golden age of piracy, which was between about 1650 and 1720. But piracy, of course, is a much older phenomenon. If we go back to very beginnings of ancient Greece, already Homer speaks about pirates, and piracy was a phenomenon that appeared as soon as humanity started taking onto the waters on boats. However, today, piracy is popular in antiquity until it was eradicated by the Roman Empire, at least on the Mediterranean. Then it returned in the Middle Ages. By some classifications, Vikings were also pirates, and so on and so forth. And then we have this apogee of piracy with the colonization of the so-called New World by the Europeans. And then, as I said, between 1650 and 1720, we have the height of piracy with about 2,500 active pirates on the waters. Of course, piracy can not only a European phenomenon appearing also in the Mediterranean, but conducted by Muslim pirates, which were known as corsairs, or on the South China Sea, and more broadly speaking, the Indian Ocean with various Chinese pirates, Japanese pirates, Vietnamese pirates, Indian pirates, and so on and so forth. After the so-called war on piracy in 1720s and 1730s, we have a decline. We'll speak about it in a minute. And then we have another eradication of piracy by empires, this time in the 1800s, and a return of piracy at the end of the 20th century, about which, again, I will speak in a few minutes. But whether or not we think about piracy in antiquity, we think about piracy today, in the end, the imagery, the collective memories that we have stem from that golden age of piracy, because that's perhaps the time when piracy was most useful for the different empires, most useful also as an instrument for law and the spread of Western law, and with that, the spread of Western ideals. That is until it outlived its usefulness, when we have this switch, as the title of my presentation suggests, from laws victors to laws victims. So let's delve into that. Right. So, why we think about piracy and law as something completely opposite one another, in reality, piracy and law have been connected quite a lot. As already in the Middle Ages, we had the possibility of so-called reprisal. So let's imagine that there's a war between England and France, as well, typically there was one in the Middle Ages, and let's imagine you are a neutral merchant traveling from what is present-day Netherlands to England. However, you are attacked by a French vessel who mistakes you for an English vessel. And as such, your right to reprisal is born. So you, as this neutral merchant, are allowed to attack any French ship and take your reprisal there. So, of course, we have to imagine that these are times before the modern-day arbitration proceedings were invented. So that was, as a way, a counter role of law to allow for some sort of compensation for the neutral states. So this evolved into what's so-called letters of marque or letters of reprisal, which could have been granted and permitted some sort of semi-legal or legal piracy, about which I'll speak in a minute. So by the time we arrive at the golden age of piracy, the legal status of many pirates was very complex and quite often ambiguous. There are different laws in different regions, different countries recognized letters of marque and reprisal, while others, like Spain, perceived all pirates as pirates. So much for law. We have to also remember that the emergence of international law, specifically international maritime law and international law of war, also appears at that time, and the conquest of the New World and the issues of piracy are some of the main motivators. Because Hugo Grotius was asked to write his treaty, Mare Liberum, or the Open Seas, in defense of the Dutch ships that have attacked Portuguese ships on the South China Sea in protest of a monopoly that Portugal was trying to have on the trade with China. So Portugal accused the Dutch of piracy. The Dutch said that they were just exercising the right to free trade. And Hugo Grotius was invited to write one of his most famous treaties, which is, of course, Mare Liberum, the basis of modern-day instruments, such as the United Nations Convention of the Law of the Sea from 1982. And of course, as I mentioned already, piracy deeply connected with the colonial expansion. Why was that? Why was piracy so deeply connected with colonialism? Well, one, of course, is that wherever new trade routes appear, pirates appear as well, something we have to deal with in the present day as well. But perhaps very importantly, while we have these images of great European navies going to the new world and conquering new for Europeans territories, the reality is that navies in the 15th, 16th, and 17th century were most often very weak. And whenever there was a war in Europe, it was impossible to send a large number of vessels to the colonies. As such, pirates were very useful because one could use them to combat enemy interests in the New World without, for example, officially entering a war with a particular power. Or maybe if there was one war, then pirates could have been officially co-opted to help the navies. Quite often, and that was the case in the Caribbean and of the east side of east coast of North America, quite often pirates were also used in defense of colonial settlements against attacks by other colonial powers. So we have a very particular relationship that used to be quite symbiotic for about 200 years. Right, and I already mentioned the non-European pirates, and while they are very interesting, I think it's best if we don't delve into that deeply beyond what I already said. But it has to be mentioned that the Barbary corsairs, especially who managed to venture as far from what is modern-day Algiers, Tripoli, and Morocco to not only Ireland and what we call United Kingdom right now, but even as far as Iceland in their raids. So there were also motivating legal responses in international treaties. And finally, they motivated the first United States intervention outside of North America, because when Thomas Jefferson was president, he decided that the Barbary corsairs need to be defeated after their attacks of American ships. And that's how the American Navy was born, and the United States Marines were deployed as the first foreign intervention of the United States of America to combat Barbary pirates. So we can see that these intersections between law and piracy was quite large already back in the day. Right, so what motivated people to become pirates? It was the same motivations as we can see right now if we investigate Somali piracy, for example. So of course, high potential to accumulate wealth. So a successful pirate after one successful haul. So let's say after 2-3 years of being a pirate, could accumulate as much money as a typical seaman got in 40 years time of work. Similar, of course, issues right now. When you take a look at Somali pirates, they can be paid multiple times of what they would have been able to make in a year in Somalia. But harsh living conditions and linked to that economic inequality. So when people were promised good life in the new world, of course, it was not like everybody received plot of land and possibility to start a plantation or farm. Most people were sent to the New World on on short-term contracts that then were oftentimes abused with very bad conditions of work. And as such, a lot of people either ran away or after the contracts ended, they had not much to show for it, not much to come back to Europe with, and as such decided to become pirates. Again, similar issues arise right now, be it in Somalia, in Gulf of Guinea, on the other side of Africa, or in the South China Sea. Difficult living conditions mean that the different peoples are driven to piracy. Right, so when we talk about the so-called legal pirates, there are two types. The first are the buccaneers. Some of you may know these names, these particular names. So these were particular groups of sea marauders composed of former sailors, hunters, and indentured servants who, as I said, didn't want to come back to Europe without much money or any money to show for their time in the New World. So they settled on some of the Caribbean islands. They established particular systems of local governance, famous pirate codes that were quite advanced for that time being, and they had official support, especially of England and later UK and France, engaging in piracy against Spanish vessels, and so at times of peace and at times of war, as I said before, co-opted officially to support the different navies. The other group was privateers, and these were officially licensed pirates. So privateers received the letters of marque or letters of reprisal I mentioned before, which stipulated exactly what kind of ships they were allowed to attack, what kind of what they should do if they managed to loot a ship and get a prize. This meant that a prize would be taken to a court in one of the colonies. The court would examine whether or not the prize was lawful, and if that was the case, then the prize would be allocated to the captain and the crew, with, of course, the crown taking a significant part of the prize. So privateers, officially state-sanctioned pirates. It meant that pirates were officially licensed to attack, for example, by the King of England, only Spanish ships in the Caribbean. This meant they were not allowed to attack any other ships, which in reality didn't happen. Quite often pirates abuse those letters of marque and attack different ships as well. But a very particular and interesting case of officially state-sanctioned piracy. So what happened? So as I said, in this initial phase of colonization, pirates were useful allies. However, by 1720, they became mortal enemies. So as I said, during the early stages of colonial expansion, piracy was very useful to supplement and bolster both the economic and military interests of the colonial states. However, by early 18th century, colonial states became more consolidated. Navies became greater of the European nations, and piracy came to be increasingly considered as a threat. Various reasons, not only greater military capabilities, but also economical. Because in this first phase of colonialism, states were interested in trade monopolies. So piracy was useful for both officials in the colonies and back in the metropole, because through their attacks on different ships, through their acting as smugglers at times, they allowed local crews to avoid local populations to avoid trade monopolies. However, by the 18th century, the European states are no longer interested in monopolies, they are interested in the free trade, and piracy is a threat to free trade principles. And of course, a state wants to regain its monopoly on violence. As Max Weber tells us, monopoly on violence is one of the main principles of state power. And as I mentioned, as colonial states became more consolidated, they want to regain fully that monopoly on violence. So by 1720, we have major legal crackdowns led especially by United Kingdom, but also other colonial governments who begin the so-called war on piracy, which lasts about 10 years, but de facto until middle of 19th century. So we have changes as to how trials of pirates take place, changes of how pirates can be now tried in the colonies. They also can be hanged directly on ships. And we have a very violent campaign against pirates, transforming them from those victors of colonial law to its enemies and victims. So as I mentioned, 1720s, significant increase in the arrests and trials of pirates. Throughout the 18th century, British naval dominance on the seas is established, with Royal Navy expanded, with reducing the numbers of
2 minutes left.
pirates. Sorry? 5 minutes? Yeah.
2
yeah,
minutes. 2 minutes.
2 minutes. Okay, yeah, I'll be concluding soon. Thank you. Of course, some of the previous speakers also spoke much longer than 20 minutes. So if I need an extra minute or two, I might grant myself it. And 1856, abolition of privateering through the Declaration of Paris. So all countries but one signed the Declaration of Paris, which banned privateering. I'll usually ask people to guess, but since it's an online speech, I'll just tell you the United States did not sign the Declaration of Paris because that would require constitutional change. The US Constitution allows in Article 8 for Congress to grant letters of marque and reprisal. So they still have that possibility to these days. So to finish off, why do we still need to think a bit more about piracy as victimhood of law and victors of law today? So first of all is the resurgence of piracy at the coast of Africa since the end of the 20th century, but especially in the first decades of the 21st century. So after the Cold War ended, we have a lack of interest of the great powers in various parts of the world, including Africa, which led to the destabilization of certain regions. And as such, somehow forgotten by the international stage and international law, people turned to piracy. A big impact in that is what is called illegal fishing. So including also some European companies, but especially Chinese and other companies. We have great fishing fleets which go to countries which are unable to enforce their water enforce control of their waters. They overfish. Then local fishermen are left without their life wages, and they cannot survive. Of course, also external factors, Houthi pirates, the current threat on the Red Sea is funded by other states, such as Iran, for example. Calls for privateering licenses in the US. So just last year, there has been a bill introduced to the US Senate by one of the senators who called for the reintroduction of reissuing of letters of marque to fight cartels on the Gulf of America or Gulf of Mexico, depending how we look at it, to protect American interests abroad. So if that comes through and actual letters of marque are enforced, that could lead to further complication of this legal situation of pirates as both law's victors and law's victims. And of course, all of these would have, we already have complications on trade. There's a lot of shipping companies now ships around Africa rather than through the Suez Canal due to these recent attacks in the last few years, which of course renders costs much more expensive. So just to finish off, this historical narrative of piracy and both piracy today reveals a duality in the perception of pirates. Because also today, if we think about it, if conditions on the ground in Africa and across the different places where we have seen resurgence of piracy were better, that would prevent the local population from becoming pirates, meaning that and the actual costs would have been much lower than the ones that all of us have to pay right now with ships diverted around the coast of Africa, which can add up to $2 million for a single trip for a commercial vessel. Thank you very much. I'm looking forward to any and all questions, and I hope this was a, let's call it a reprieve in a way, a different perspective on how legal victimhood is created. Thank you.
Okay, thank you very much for the nice talk. As we're a bit over time, I will forego my comments of the summary of the presentations, but thank you to everyone who has presented. And now I will open the floor for any questions. We have 15 minutes before the coffee break, so please raise your hand if you have a question. Yes, over here. Yeah.
Hello, I have a question for Dr. Brendan. First of all, thank you for all the presentations. It was really interesting. But I would like to ask you, as a historian, you were talking about, for example, Serbians, and you were also asking a great question about vicarious perpetrators and the guilt and how it goes for the generations. And while talking about the Serbians, you mentioned World War II, how they were killed. But my question is, if they were some kind of victims, not some kind of, they were victims of this brutal war, how do you think is that not even a decade later, a genocide as Srebrenica happened? Could you maybe comment on that?
Thank you for the question. It's a very depressing conclusion that a group who suffered genocide in the 1940s then committed it in the 1990s. I mean, this does not tell us anything wonderful about humanity. And I'm in a room of legal scholars here, and from my point of view, this word genocide, I mean, it has to be kept as a standard, and it's really the lawyers who have to work this out, but it has become the political football. So many people, and this is again, I think, a very strong symptom of collective victimhood, so many people claim that particular atrocity against them amount to genocide. And then it becomes a matter of, politics and propaganda, which it should not be. Depressing conclusion is that, yes, of course, people who have suffered this in one generation are capable of carrying it out in another. It's a pretty bleak conclusion about our humanity, but that I can't, can't say anything more than that. I always say I'm a historian, not an optimist.
Thank you for your presentations. Also a question to you, but it's open for others as well. Unlike you, a historian, I'm from legal philosophy with a main focus on human rights. So my question is, does a specific language used in all the various stages or ideas of victimhood that you presented in the first part of your presentation, can they be seen as, well, designed to trigger targeted emotional responses, but also function as a form of psychological conditioning, which can violate an individual's freedom of thought?
It's a formidable question. I'm not sure I've got it on the first asking. Is the particular language then that's something that's going to trigger psychological reactions?
Yeah, so you were talking about how there's different stages of victimhood, saying, oh, well, we bonded, we move on, or...
Oh, the denial in this particular case, yes.
So all these kind of, the languages used, well, they elicit certain emotions from the people. Could they also be seen as to violate an individual's freedom of thought or to think? Because now we have these emotions to go on and we react a certain way to these events.
That's a very interesting point, and it is one of the things that Cohen speaks about in denial theory, is that the actual responses are always culturally conditioned. I forgot to mention I'm giving a seminar here on Friday in which I'll be speaking about prisoners and guards' reactions, which I did a field study in Croatia. And that is one aspect of that the responses are usually culturally conditioned. We'll get down to it more, particularly when it comes to the self-justifying narratives of convicted inmates. They're always innocent. They always have a way of creating a certain life narrative that somehow or other tries to justify to themselves what they have done. That paradox that Cohen speaks about of simultaneously knowing and not knowing, trying to be free of that troubling recognition. That comes down to their individual life stories, but it's also what they learn in prison, that way of creating, if you like, self-serving life narratives, which is very, very developed even among prisoners, and it is something that they learn in the culture of prison. So I think that addresses some of the points you raised, maybe not fully.
Hello, everyone. My question goes to Dr. Humphrey. If we are discussing the invasion of Ukraine as a modern struggle against imperialism, what about acknowledgement of past European crimes, like that of King Leopold, who killed millions of people in Congo? Thank you.
It is a strong movement to try and recognize some parts of the difficult past. I think it's been a gradual. I don't know Belgian history that well. I'm aware of the famous book Saint Leopold's Ghosts, or not Saint Leopold's Ghost, King Leopold's Ghost. He was certainly not a saint. And the unwillingness of European powers to admit to the wrongdoings when they were running empires. This is an enormous historical amnesia, yes, and I can understand the frustrations of people in the global south and in ex-colonies that somehow or other you make excuses for this. There are, of course, compensatory measures. I was 2 years ago in a very lively British city of Bristol, in which there was a lot of public statements. When the old port there has become a kind of a museum area, and there was public acknowledgement that yes, Bristol did benefit from the slave trade, and we now have to, in retrospect, recognize that. So there are, in some cases, compensatory measures in place, but whether they're sufficient or not is, of course, another story. I think they probably have, at best, symbolic value. And whether that's sufficient or not, I cannot say. It has to be the people in the ex-colony who, I think it is their word as to whether there has been sufficient acknowledgement. And then there's, of course, the legalistic and financial aspects of reparations, which is something I know very, very little about. But I think it is for those people to decide whether there has been sufficient acknowledgement of that.
I just want to ask our Ukrainian participants about what do they think about how much time will take to punish our aggressors. No, I mean in this tribunal, how it will take time and when it will be, after war or during this time, because all the time we see all these atrocities but no consequences of punishment. Thank you.
Thank you so much for your question. I will start, and maybe then other Ukrainian speakers would like to comment, or not only we are. So basically, the process is already started, starting from the national jurisdictions. But if we are talking about the international perspective, unfortunately, for the moment, it's only the start. But if we compare the different conflicts, we can see that nowadays the process become faster than it was during other conflicts, because have already we see the cases in the ICC that already started, and also in the framework of special tribunal, that at least we have the framework that negotiated, and also trials in Ukraine, and as well as, for example, if I'm not mistaken, in Finland we also have some trials, and when the perpetrator was prosecuted not in absentia but in person, and in the framework of universal jurisdiction about which I have spoken. But of course, the process will be not for 1, for 2, and unfortunately not for 3 years, because of the scale of the crimes that were committed. And in my presentation, I show you the number of crimes. So again, it's not only about trials in absentia, but also we need to have perpetrator on bench. Yeah, thank you.
If it is possible, I also would like to comment, and everything will be depend what guilty person we speak about. If we speak about big fishes, everything will be depend with political situation. It's necessary to say economical situation in aggressor country, and it's necessary to find good time for good justice. And if we speak about other war crimes, crimes against humanity, soldiers of Russian army, and it's necessary to say that we have procedures in national jurisdictions, first of all. We have some verdicts in Ukraine, not so fast as for me as possible. We would like don't to use in absentia procedures. It was, but it wasn't good for defense of this person, guilty persons, accused persons, and it's necessary to say that all of these procedures in international and national justice, as for me, for decades. It's not a question about fast justice. If we speak about results of Russian-Ukrainian war in legal sphere. Thank you so much.
Just could you add about the main authorities in Russia? Would they be punished or not in future? What's your opinion? Because after the visits to Ankara, you remember, we have another scenarios. What's your opinion?
Everything is depends with political situation, I said. For example, you know situation, maybe you know, about situation of Holodomor in Ukraine. In Ukraine, we had decision of our national court in Kiev about results of Holodomor. And they named the guilty person, Joseph Stalin, and other high-level communist representative of Communist Party in Soviet country. But is this justice or not, or it's just historical document? I think it's historical document because we didn't see this persons as in real court, and nobody knows what will be result of legal procedure if we speak about Mr. Putin, Mrs. Lvova Belova that received order from ICC. We don't know how it will be. I think real justice can be if we have good political basement, and not only political basement, you can understand easily, economical basement, international basement, etc.
So, thank you for all the presentations, and I will have 2 questions. First of all, the question will go to the Mr. Mikhailov. So you talked about the status of the victims, and you said that to repairing this kind of the status is very hard. So what is the reason behind not to repairing it easily or just not getting it? Do I need to? Yeah, what's the reason not to repair that kind of the status easily? Reparation of the victim status.
Yep. Thank you so much for your question. If we speak about reparation in national mechanism of justice, it's necessary to have big fund of trust fund or other fund to restore the rights to property and first of all to property and maybe moral things, and it's necessary to prepare real justice in verdicts. It's necessary to find guilty person. It's necessary to catch them. It's necessary to prepare real justice for reparation in sphere of after the court. And main idea is that we can support, we can find this money. Certainly it's a big problem, but we can find this money. But if it will be after the verdicts, it will be after some years. But our victims of these war crimes, first of all, it's necessary to support them immediately. And what is reparation? Can it be named reparation after 3, 4, 5, 10 years after the real damage? It's key question. And because of this, I demonstrated that we have good state program of e-restoration, e-відновлення in Ukrainian language, and this person can receive some money, some support comparatively immediately. And because of this, we speak about it.
Okay, thank you. So my second question will go to the Mr. Satowski. So you talked about the piracy and international law. So how the states can handle the international law obligations for the piracy? For example, in Djibouti, in the Gulf of Aden, so there are a lot of piracy attacks on the ships or cruises, just getting some kind of the money to return those people. So it's increasing day by day. So how can the states can handle this these problems under the international law?
Thank you. That's a very good question, and unfortunately, with a lack of a good answer, because we in international law we don't have any permanent instruments to properly combat piracy. All the states are supposed to cooperate in the fight against piracy, but how this fight will look really depends on them. So the last time we had a resurgence of piracy at the early 2010s, we had a major global coalition thanks to particular UN Security Council resolution and resolutions over the years, which allowed a big international coalition, such as with vessels from EU, from NATO, from the US, from Canada, from China, Iran, so very different places coming together to combat this pirate threat. But these were all ad hoc measures, and they ended. Security Council didn't prolong them. I think last time they prolonged them, it expired 4 years ago. Obviously, Security Council has not seen eye to eye on much ever since. So we don't know. The current threat, as you mentioned, is rising. The Houthi attacks continue. Houthis have begun collaborating with terrorists also in Somalia. So we may end up with a very, very problematic situation with lack of proper international answers. And even when it comes to trying pirates, we don't have any established mechanisms, because when European nations try to try pirates within EU courts, it led to a number of issues and several cases before the European Court of Human Rights, which said that the human rights of pirates to speedy trial were not respected. And obviously it's not possible if you catch a pirate off the coast of Somalia on a let's say, a French vessel, it's impossible to transport them immediately to a French court. But the European Court of Human Rights disagreed and said that still these rights need to be respected. So right now there have been a number of agreements with places like Kenya, Mauritius, to try the pirates there, but they haven't been particularly successful. So basically, it also means that the pirates know that at many times they will just, even if they are caught, they will be released quite quickly for fear that the compensation will need to be paid in case they are tried in Europe. So they know that there is impunity possible, and yeah, no good answers from international law, at least at the present moment. But thank you, excellent question.
Okay, we have one comment from online. So Professor Dr. Tolikov, please feel free to speak now.
Well, thank you very much. We hope that you're hearing me. Maybe I will have two comments regarding two last questions. The first regarding pirates. It's very interesting, but President Yanukovych sometime, well, maybe 12 years ago, or 12 in 2010, yes, in 2012, 15 years ago, he just presented a draft of United Nations Convention against Piracy. By the way, just that was an ambitious project. Yes, it was connected with the ideas of Hassan versus France and other cases in ECHR, but maybe the first mechanism we use, that is the CLOS, United Nations Convention on the Law of the Sea, where piracy is just recognized as international crime and the first crime of universal jurisdiction. That is the first. And the position of struggling with piracy, pardon me, but now it is in fact just working with private military companies or private security companies, because that is the lack of characteristics of them in European or international level, and that's why these actors are working in the gray zone. And they are working with the pirates, because the effectiveness of working for PMCS in just Somalia is 100%. The second question regarding compensation, restitution, and so on and so forth. Just try to understand that in Ukrainian legislation, unfortunately, the huge amount of questions regarding compensation, restitution to victims is not just working properly. Yes, we have special articles in our civil code, we have special articles in criminal procedural code, but we have not a lack of money for doing that. That's why nobody can say about reparation, but we have not to say something about compensation and redress. Thank you.
Yeah, but just say thank you for this comment. We had the draft convention. It never happened. Quite often, unfortunately, it does with the United Nations. The private military companies, yeah, of course, they are contracted, but the problem is that there have been many studies that show that since they are private military companies, they are not exactly interested of bringing pirates to justice, and also a lot of shipping companies are not interested in that, because it's much quicker to pay the ransom, which again doesn't exactly help mitigate the threat. It's just that some companies are known to pay, and as such, maybe they will be safer in the end, their vessels, because they just pay every year to pirates. China has been known to pay Houthi pirates, and Chinese ships are not attacked when they cross the Red Sea right now. But again, rather than combating the threats, it means that people are drawn to piracy, because it means that they can quickly make money. And of course, present day pirates are not this down-to-earth people or semi-organized as back in the day, but a part of often big criminal conglomerates. So yeah, but thank you for this comment.
Okay, well, in the interest of time, thank you for everyone's questions and comments. We will go on the coffee break now for 20 minutes. So we'll be back here at 12:30 for the next session. So thank you very much and see you soon.
Well, thank you very much. It would be simpler to call me Slava because sometimes Vyacheslav it is not very pronounceable to English-speaking users. Okay, regarding the theme of my presentation of nowadays, just when we're saying about victimhood and when we're saying about victims of crimes, just we remember that where there's a huge amount of information which is connected with criminal law and force. But let me ask you only one question. Could you tell me if they're in Europe or in European countries in just statutory criminal law, a notion of victim? From one point, we're saying that, okay, guys, we're staying now at the victim-centered turn in international law regarding ICC or Ljubljana, the Hague Convention of just mutual legal assistance on international crime with special victim section in soft law of the United Nations when we're saying about basic principles of justice for victims of international human rights conflict and basic principles of justice for victims of crime and victims of abuse of power. Yes, we have these documents, but could you tell me if a victim is a member of criminal legal relationships, where is the notion of victim in our criminal codes? Such in one criminal code in Europe. Well, there was a chance in Italy in 19th century, but now it is not. No criminal code, no substantive criminal code in Europe has a definition of victim. No substantive criminal code in Europe has a special part regarding victim as a procedural figure. Yes, in 2023, the Council of Europe, the Committee of Ministers of Council of Europe in March of 2023 has signed a document, and this document was called, well, a Special Victim Protection Declaration. And this victim declaration, there was a very interesting moment when they say that crime should be analyzed as a harm to victim and then a harm to the state. But this shift, well, is reflected only in procedural rights, but in substantive law and human rights discourse, it is not working properly. And that is why when we're saying about victimhood as a security deviation, which deviates from security norms operating in legal and intuitive level, there are some paradoxes we have to analyze. The first one is recognition versus instrumentalization. The more system recognize victims as right-bearing system, the more readily political actors just try to instrumentalize victims' narrative and to justify punitive expansion. It is a tradition. It works in every society. Just remember, we don't like in Ukraine now, just by the way, because of some ideological aspects, we don't like Nobel laureate Joseph Brodsky, but Brodsky in his speech in Michigan, well, a huge amount of years ago, which has said that it's any right, try to avoid not being a victim. And that is the case, because political actors have to try to get these victims suffering out. They want to create new narratives. And that's why, for example, we're saying about just very interesting moment in Ukrainian legislation. Yes, now we have a special martial law. Yes, super, from one point of view. But could you tell me, or international auditorium, or representatives of national authorities, academia, could you tell me where this law ends? What should we do? Do we have a special restrictions, limitations after sunset, so-called sunset rules, regarding victims of crimes, regarding compensation, deviation, and so on and so forth. Unfortunately not. The second, voice and procedural fairness. That's why, for example, we're saying, just my connection with the European Court of Human Rights just could give me the possibility to analyze some special cases. And Paris versus France sometimes said that victim participation must not compare with defense rights. And that is a typical situation now in Ukraine, for example, when we're saying that victim is the first. Yes, super, morally, we should do that. We can do that in any situation, but from the other points of view, try to understand. Sometimes we are given in a very specific moment when we are starting a fair trial, where we're starting a balance between victim and perpetrator. What should we do in that? Unfortunately, sometimes we will look at Article 6 in this connection. This third one, protection versus over criminalization. We have to create new offenses. But sometimes these new offenses should be not confirmed with the principles of legality. Sometimes these new offenses or new policy of the states should not be confirmed with the European Convention on Fundamental Rights Protection. It should be contradicted with them. Just try to understand that. In December of 2025, a huge amount of states just have criticized the European Court of Human Rights on the position of migration. And my country has signed this document too. And now there is a question why the ECHR has to use Article 3 or Article 8 of European Convention to combat with the violations of principles of migrational policy of some states. You know what I mean. And that is why victims' interests should not justify and should not be in compromise with legal certainty of the documents when we are saying that the state has the right to, well, abuse. The state has no right to abuse. It is the component position, and when we're saying that, okay, let it be let me minimize the essence of Article 3 of European Convention. That is the violation, and that is the violation of over-criminalization which we have. The fourth paradox, vulnerability versus agency. Sometimes we say that victims are passive to trigger protection, but what should we do with the survival strategies? Okay, huge amount of questions we have regarding sexual violence and usage of rape as a weapon of war and so on and so forth. It used. But in international criminal practice, and when we're saying about ICC and ICC legal, it would be a very strictly limited thing. Why do I say that? Because complex survival should not be ignored in the documentation. And victim is not a pure victim. Victim is a man or woman who lives in a special society and who have a special aspects of doing that. Hierarchy and universalization, I like that. Just this day, and then our conference is connected with not only with the Ukrainian case, it is connected with the case of huge amount of victims in the whole world. So Syria and the Yemeni Rohingya victims remain marginalized up to nowadays. So what should we do and what should we say about victims of crime in Latin America? 90% of homicides just is located there. But from the other point of view, it's very interesting. Just when we're saying, for example, the El Salvador and Bukele practice, yes, it violates human rights. Okay, yes, but Last year, I had my lecture course in human rights in ESSEC University in Spain, in Madrid, in Pozuelo. And some of my students were from El Salvador, and they say, okay, yes, it violates human rights, but after that, we feel more safer. What should we do about the safety while violation? What should we do, and what should we say about the use of special norms? The same position we have now with the war crimes in Ukraine. Just I can't understand that, and I just criticize that a huge amount of time. Just when we are registering every war crime as a sole or single war crime, try to understand 200,000 war crimes, and every shot, every bombing, every shelling, we are qualifying as a single war crime. But maybe that is not a single war crime. Maybe that's when we're saying about the usage of bombing, usage of rockets for one city for one day, that's the whole episode. And we should note, we should analyze, but should qualify is with another work. And that is why just ranking victims of crime from one point to the second is a very huge problem. And exactly what I'm saying about war crimes and the situation with war. Next one, just retributive expectations of victims. Yes, we say a huge amount of words about that, but it's only words. When they're saying about, well, victim-centered justice of the ICC, what should we look at? We know that there is only one symbolic compensation of, if I'm not mistaken, 2,000 victims. And that is all, because there is a lack of money. There's a lack of funds for doing that. The same position in Ukraine, because the special victim-centered legislation is not working. Unfortunately, not working. Yes, we have just now these two special programs for just broken property. But from that point of view, you know that Article 1177 of the Civil Code of Ukraine gave the possibility to states to compensate everything. But we don't do that. That is a tendency, because community reconciliation initiatives are not working, and we are trying to harsh sentencing, and that's all. Maybe it is interesting, but from another point of view, this retribution is not working properly. And just only to note, Ukraine has signed a Convention on Compensation of Victims' Crimes, the European Council Convention, in 1985. Now is 2025. And this convention has signed in 1985 is not ratified because of lack of money, because this of punitive demands. Seventh paradox, privacy versus visibility. It is very interesting, but victim protection requires confidentiality. From the politician view, we have to analyze everything and to say, okay, guys, this woman was raped. Let's interview her. Let's give this interview to international auditorium. Is it possible? Is it right to do that? I can't say anything about the special rules on victim protection regarding Article 8, regarding just visibility and privacy, but it is and should be specially pressured by justifying moments. The last, emotional legitimacy versus normal restraint. Yeah, special collective emotions are morally valid, but from the other point of view, when we give special sanctions on use the special treatment without notice of victims, yes, or with the notice of victims, it is very interesting balance. For example, if we have two defendants, one defendant with victim impact statement and another without, could you tell me what should be the difference in sentencing? And should it be? And from the other points of view, why could we make this emotional legitimacy more effective. For example, now the court, Supreme Court of Ukraine just said that victims impact statement is not working in some situation when the judge have the possibility to release people from defended from criminal responsibility. Very interesting position up to as to me. And the next question which arises, European Victims Directive in 2025 addition. Yes, in December of 2025, just the Directive of Victims' Rights of 2012 was just faced a fundamental reform connecting strengthening procedural rights, special EU-wide helpline, enhanced protection of vulnerable groups and children, and so on and so forth. It's very interesting. But could you tell me, my dear friends, since 2012, how many countries has introduced directive in national legislation? Why do in 2020 well, the procedure of infringement was begun by the European Commission against, if I'm not mistaken, 70% of countries. Why do victim protection consideration should not work in Europe properly? Up to 2025, we have a roadmap, and now we have a new updated victim rights protection directive. That would be the case for Ukraine too, because we should declare victim centricity, but we'll implement it through punitive and symbolic acts. Maybe if directive requires special procedure, service, and cultural change, we should be in conflict with the process of legality and proportionality. The same way should be connected to minimize this strengthening participation in criminalization processes. I can't say anything about the consequences of special legislation on collaboration on or Article 111.2, which criminalizes...
That's 3 minutes left now, thank you.
Thanks. Well, but the question is that if we're saying that victim position is not the serious, if we're saying that special victimless crimes in this situation, it should be the legislation should be more punitive, nor just procedural rights. And the last, symbols. Maybe we need, and I am very strongly support to create a helpline infrastructure in Ukraine for victims, because these special victim support services are very interesting. Just, I remember the fact when I working in the United Nations ad hoc committee on creating the first in the United Nations textbook on declaration of victims of crime. Just we look at just in the US maybe 300 special helpline infrastructure for victims was in every state, and that is the case. It is working if we need that, and that is why we should look for more sophisticated protection of victims in every connection. The last maybe position, this position not connected with procedural service, professional training. As for me, it should be connected with the sunset clauses. The mandatory review of extremely boresome norms. What should we do after? For example, at the beginning of just open part of aggression in 2022, we criminalize theft in wartime, the theft of wartime, 7 years, etc. What should we do after? When the wartime ends, when the martial law ends, what should we do with these people? How could we use the power of non-victimizing that? And to navigate this paradox, we have to look to proportionality discipline and transparency and trade-offs between competing values. That is the last. As for me, victim-centered justice is a legitimate goal for all European countries, but that is not an overriding principle regarding the principle of, first, the principle of legality. And that is why an Article 7 of European Convention should be at the center of it, and simultaneous validation of victims should be working properly. Thank you very much. I do hope that we have a very good time for giving my presentation.
Thank you very much, Professor Tuliakov, just so I don't mispronounce your name again, for a very, very thought-provoking and very thorough talk. Yes. Moving on, unfortunately, Dr. Monica Rogers from here is ill at the moment and cannot be here in person. She's done so much to organize this particular conference. Luckily enough, we do have her presentation. And yes, we'll go ahead with that. This is like at the Oscars when you get to get somebody else's prize for them. So
about between East and West, victim and victimhood in Baltic countries. And in her paper, Monica Rogers tried to address how the concept of victimhood and understanding of the victim's rights was developing in Baltic states from 19th century during interwar period occupations and since recreation of Latvian, Estonian, and Lithuanian independence in 1990s and their Euro-Atlantic integration. The methodology that was used is interdisciplinary, from history of ideas to victimology and criminology. And basically, in academic tradition, Baltic countries are usually described as a geographic region where East meets the West, or the bridge between the two. However, historically, the differences between Latvia, Estonia, and Lithuania are considerable. While the first two is medieval and early modern period were ruled by different state formations under the term Livonia, including Swedish Livonia, today's Lithuania, was a part of the Grand Duchy of Lithuania and Polish-Lithuanian Commonwealth. These historical and political circumstances defined different legal traditions as well as different ethics based on the fact that while Lithuania and Estonia were under the influence of Protestantism, what is geographically a present-day Lithuania was mostly Catholic. These circumstances did play a role on the formation of the concept of victimhood. However, in the 19th century, the whole region, except the small part of Lithuania called Užemunie, that was ruled by Prussia, was under the jurisdiction and therefore legal and cultural impact towards the concepts of victims and victimhood of the Russian Empire. After the First World War, all three Baltic countries formed independent states. They lasted until the early 1940s. This period is seen as a foundation for the birth and consolidation of the idea of joint Baltic states identity. Little is known, however, that despite independence, all three countries still used modified versions of imperial Russian criminal laws. During the Soviet occupation, which was interrupted by the occupation of Nazi Germany between 1941 and 1944, Baltic region was a part of Soviet legal system. The Second World War and the Nazi and the Stalinist violence were themselves very important factors in formation of Baltic concept of victimhood. Holocaust and Soviet Stalinist repressions became a huge part of this Baltic victimological discourse. Soviet period was also a period when shared jurisdictional, social, cultural, and geographic definition of so-called Baltic Soviet republics, at that time usually defined by a Russian term Pribaltika, that when translated literally means by the Baltic Sea, found even more common grounds, even nowadays. During Stalinism, all three Baltic countries experienced forced mass deportations, other harsh repressions, and formed armed anti-Soviet resistance movement. Late Soviet period dissidents in three Baltic countries established contacts and formed a shared collaborative network that resulted in one of the most considerable Baltic anti-Soviet protest documents, the Memorandum of 45 Baltic Citizens, also very well known as a Baltic Appeal or Baltic Charter. It was a historic public letter signed by 45 Estonian, Latvian, and Lithuanian nationals, issued on August 23, 1979, the fourth anniversary of the Molotov-Ribbentrop Pact. In the late 1980s, the Molotov-Ribbentrop Pact became a symbolic leo de memoriae, giving the framework of the Baltic-specific victimological identity, which can be defined as the idea of three Baltic countries as the victims of the repetitive historical conquest and violence committed by the larger imperial powers. First of all, Germany and Russia. So it's important to discuss how this concept of the innocent Baltic victims caught in between of the symbolical and actual colonial violence coming from both symbolic East Russia and West Germany is reflected in Latvian, Estonian, and Lithuanian legal and criminological discourse since 19th century until the end of 20th century, when it was modified but not erased by the Euro-Atlantic integration of three Baltic states. Three strands of victimological discourse in Baltic countries Monica would like to present here. The first, the already mentioned discourse of colonial or imperial victimhood. This tradition of collective memory and this experience of transgenerational trauma of political war violence and lost statehood from divisions of Poland, Lithuania in the end of 18th century to already mentioned Soviet and Nazi occupation during the Second World War formed a very strong discourse of victimhood in the framework of transnational justice. This can be said about all three Baltic states, Lithuania, Latvia, Estonia. They all paid attention to restore justice when it comes to Soviet crimes. For instance, lustration in Latvia involved legal measures implemented after 1991 to restrict former KGB agents and Communist Party officials from holding public office. Key efforts focused on vetting electoral candidates, civil servants, and military personnel. This was understood in the country as an example of former Soviet victims who took back their agency to deal with their perpetrators. While in Lithuania, criminal prosecution of both Soviet and Nazi perpetrators did happen after the declaration of independence in 1990. There are some differences, however. While, for example, Latvia and Lithuania have specific laws criminalizing Holocaust denial, Estonia doesn't have such specific law, but the Estonian Penal Code prohibits public incitement to hatred, violence, or discrimination based on race, nationality, or religion, which can be applied to Holocaust denial cases that incite hatred. These legal norms, however, in Estonia can be used to prosecute for Holocaust denial. Problematic side of such victimological discourse is dealing with local perpetrators and collaborators who themselves, being victims of totalitarian regimes, committed crimes against humanity and war crimes. However, it's not so much a problem of the law, but rather the politics of memory. Second discourse is the general concept of victimhood in the framework of victimology. Because of already mentioned long-term belonging to Soviet legal tradition, Latvia, Estonia, and Lithuania do lack deep roots in Western tradition of victimology. Victim rights here are protected under the general framework of European Union law. But this lack of root might manifest in different ways. For example, in Lithuania, there is a long-term, historically based pattern of neglecting rights of sexual and domestic violence victims. In the Lithuanian Soviet Union, these victims didn't get any needed protection, experienced mass-scale secondary victimization. Some of these patterns didn't continue after the restoration of independence. Until today, Lithuania didn't ratify Istanbul Convention, while Latvia has taken steps to withdraw from the Istanbul Convention just over a year after its ratification in January 2024. Parliament voted to withdraw in late 2025, just last year. And finally, third discourse and trend can be defined as lack of balance between victim and suspect rights in the process of criminal prosecution. This trend comes from 1990s, when active reforms were taking place in order to desovietize legal and criminal prosecution systems. It's also connected to positive effort to re-establish the rule of law that was neglected in the Soviet years, meaning, for instance, absence of fair trial. For instance, in Lithuania, sometimes it seems that in early 20s, the criminal prosecution officers were over-focused on protecting suspects' rights, but neglecting the victims' rights and stories. It was very hard to start criminal investigation without the full package of diverse set of evidence. While a positive trend on its own, it sometimes means that victim's side of the story was not heard. And victims' witnesses was almost never enough to start the criminal investigation. There are much more trends which we are leaving out due to the length and scope of this limited time during the presentation. Anyhow, there are no doubts that all three Baltic countries today are putting huge efforts to protect victims' rights better and to provide the crime victims all needed services and support. Thank you for your attention.
Yes, thank you for that. And the pity again that Monica could not be here in person. But we're moving on. Next we have a distinguished speaker from Ukraine, Dr. Valery Sheptiko. I'm so convinced I'm going to mispronounce everything Slavonic now for the rest of the afternoon, from the Moda National University in Ukraine. And he will be speaking on victimhood psychology and behavior during war and the post-war period, the case of Ukraine. The floor is yours, Professor.
Thank you. Dear ladies and gentlemen, dear colleagues, first of all, let me express my gratitude to the organization committee of the International Conference for the invitation and the opportunity to take part in the scientific discussion. Today, my report is devoted to the next topic, victim psychology and behavior during war and the post-war period. Some problems.
Only like this, I think.
Okay. The victim is the person who has suffered moral, physical, or property damage as a result of a criminal offense. In the mechanism of the of crime, there is a relationship between the offender and the victim. Okay. The psychological conflicts between the offender and the victim can take various forms. The Russian Federation is waging a full-scale war against Ukraine, which has forced more than a third of Ukrainians to flee their homes. Almost 14 million Ukrainians in the first 100 days of the war, and has climbed the lives of many. According to the Office of the United Nations High Commissioner for Refugees, there were 7.6 million Ukrainian refugees in Europe, 4.2 million of whom registered and requested shelter and assistance. The methods of waging this war are targeted terror in all Ukrainian region, mass murders and torture, kidnapping and rapes, forced deportation of the civilian population, destruction of the civilian infrastructure of Mariupol, Kharkiv, Chernihiv, Kremenchuk, Kherson, Mykolaiv, Nikopol, Lviv, and other cities and towns, atrocities in Irpin, Bucha, Hostomel, Borodyanka, Izum, Kupiansk, occupation of certain regions of the country, which allows us to raise the question of genocide of the Ukrainian people. The crime of aggression, the crime of genocide, crimes against humanity, war crimes are classified as international crimes. The Criminal Code of Ukraine establishes liability for the crime of aggression, war crimes, use of weapons of mass destruction, ecocide, genocide, crimes against humanity. According to statistics from the Prosecutor General's office in Ukraine, since the beginning of the full-scale invasion, 213,120 crimes of aggression and war crimes have been registered, as well as 24,170 crimes against national security. According to juvenile prosecutors, 3,026 children in Ukraine have become victims as a result of the full-scale armed aggression of the Russian Federation. Out of this number, 679 children died and 2,347 were injured of varying severity. According to various estimates, during the war, Russia could deport from 260 to 700,000 Ukrainian children. According to the Prosecutor General's office, during the first year of the full-scale war, Russia destroyed or damaged more than 81,000 civilian objects through targeted attacks, more than 62,000 residential buildings, more than 450 medical facilities. Due to massive bombing and shelling by the Russian armed forces, 3,126 educational institutions were damaged. 438 of them were completely destroyed. Russia in the 20th century destroys critical infrastructure, kills civilians, deports children, steals grain, blocks Ukrainian ports, and try to create a global food crisis. In the months of 2025, more than 1,100 drone attacks against civilians were recorded, which is twice as many as in all of 2024. The effects of the criminal activities of totalitarian regime need to be established. The scale and the number of murdered Ukrainians must be determined, and the targeted genocide of the Ukrainian people must be recognized. The genocide is a campaign of total or partial destruction of national, racial, ethnical, or religious group as such. Article 6 of the Rome Statute of the International Criminal Code states that genocide means any of the following acts committed with intent to destroy in whole or in part a national, ethnical, racial, or religious group. The victims of war can be divided in the following groups. The first, civilians, and the second, military personnel. Vulnerable groups of the population during war include children, pregnant women, people with severe mental disorders, people with physical disabilities, economically vulnerable people, and displaced persons. The military conflict is an emergence that causes psychological suffering. Extraordinary traumatic events during war include death, threat of death, serious injury or threat of injury, sexual violence or threat thereof, news of death or injury of loved ones, friends, loss of property, housing explosions and air raids, and migration. The victim's feeling may be related to depression, shame, resentment, etc. In the vast majority of cases, victims experience anxiety or fear. The most difficult reaction for the psychology of people who find themselves in a difficult situation are fear, apathy, nervous tremors, aggression, hysteria, and panic. Many people experience exhaustion, devastation, fatigue, and feel anxiety. After the 17th, 18th day of war, the psyche gets tired of constant stress and begins to get used to danger. People get tired of being afraid. Also, fear can be a constructive feeling that saves life. For example, civilians begin to ignore sirens because of this careframes. Around the third week of war, casualties among the civilian population usually increase sharply. The prevalence of mental disorder is extremely higher among the war-affected population. According to the Ministry of Health of Ukraine, the war will affect the health of Ukrainians in the long term. It is expected that about 15 million citizens will need psychological support, with 20%, 3 to 4 million people already needing the help of a psychiatrist or psychotherapist. The next 5 to 7 years will be especially dangerous for a person who fought or perceived the horrors of war. When the greatest number of psychological breakdowns occur and psychiatric consequences are observed. Example, on January 27, 2026, in Korостeń, Cherkasy region, when a group of law enforcement officers arrived to conduct an investigative action at a local residence home, the suspect fired with an automatic weapon, killing 4 police officers. The shooter turned out to be a 59-year-old Sergei Rusinov, a former serviceman who returned from the front about a year ago. The man put on a bulletproof vest, fled from his house to a forest and set up an ambush there. When law enforcement officers approached, he shot and killed them. The criminal was eliminated during a special operation. The reasons for the former serviceman's aggression are being investigated. The post-traumatic stress disorder is a mental health disorder that can develop after a traumatic event. About 8% of men and 20% of women who have experienced traumatic events have post-traumatic stress disorder. Post-traumatic stress disorder can develop in people who lost family or friends in war, saw people killed, were under fire or bombardment, worried about family or friends in danger, were captured. Symptoms of post-traumatic stress Disorder include persistent and uncontrollable thoughts about traumatic events, dreams about them, a feeling of constant danger, exists arousal, panic attacks, feeling of fear, shallow breathing, nausea, repeat heartbeat, chest pain, difficulties in everyday life, suicidal thoughts, inability to express and show emotions. A separate category of victims during the war are children. In March 2023, the International Criminal Court in The Hague issued an arrest warrant for Vladimir Putin and Maria Lvova-Belova. They are suspected of forcible deportations and displacements of the population, including children, from the occupied territories of Ukraine.
There's 3 minutes left.
The deported children are subject to negative patriotic influence, indoctrination and preparation for future military service in the Russian army. The return of deported children is a long and complex process. Deported children and their parents are victims of the Russian regime. On December 3rd, 2025, during the 11th extraordinary special session of the United Nations General Assembly, the resolution Return of Ukrainian Children was adopted. This decision is a signal that the world sees the crime against Ukrainian children, understand its scale and demands an immediate response. Thank you very much for your attention.
Moving swiftly along, I'd like to hand over to our earlier chair, William Bruden, my esteemed colleague from the University of Helsinki, who will be talking about case studies, the evolution of victimhood and victims' rights in Bosnia and Herzegovina. So we're back in the Balkans for this one.
Okay, hello. Hello, everyone. So I will be talking about victimhood and victims' rights in Bosnia and Herzegovina. So I'm going to start by discussing what I or fellow authors are discussing as what is the definition of victimization. So Vesna Nikolic-Ristanovic defines war and post-war victimization as continuing social processes rather than an isolated act of violence. And she distinguishes between different types of victimization. So the first is direct victimization, which is physical and sexual violence. Indirect victimization, which is displacement, poverty, and social disintegration. And secondary victimization, which is institutional neglect and stigmatization of state powers. And my presentation will build on definition and conceptualizes victimization in Bosnia and Herzegovina as produced through 3 systems. So the political system, which is ethno-national governance, legal systems, which I kind of used interchangeable with transnational justice, and social and memory systems, which are collective narratives and recognition regimes. And victimhood, therefore, is not merely a legal category, but it also becomes socially constructed and politically mediated identity. So just a background, I'm covering the Bosnian War. So this is between 1992 to 1995. And this was following the dissolution of Yugoslavia involving systematic ethnic cleansing, genocide, and mass sexual violence. And here a large part of the conflict was revolved around the Daytona Peace Agreement, which institutionalized a consocietal power-sharing system structured along ethnic lines. And this arrangement reinforced ethnic identity as the primary political category, embedded collective victimhood into governance structures, and institutionalized competition among victim narratives. And thus, victimhood in this area is structurally mediated by post-war constitutional design. So an important thing that we have to think about during this period is wartime gender nationalism and how it manifested during this time. So Elisa Helms demonstrates that wartime nationalism in Bosnia operated through gendered symbolism, where women's bodies became markers of ethnic boundaries, and sexual violence was framed as an attack not only on the individuals, but also on the nation itself. And Tamara Banjarglav further showed how maritime rape was constructed discursively as violence against our women. So women became a national kind of symbol in reinforcing collectivized ethnic identities. And Janine Clark critiqued the macro level explanations of wartime rapes and argues that micro level analysis, where she emphasized that while rape was strategic, it was enacted through localized power hierarchies, militarized masculinities, and social opportunities structured. So therefore, sexual violence in Bosnia was categorized under these four concepts, which are, it was gendered, ethno-national, militarized, and also locally embedded. And in this time period, rape was also used as a strategic weapon and a kind of a source of spatial technology. So research on rape camps during this time conceptualizes them as spatial technologies designed to enforce ethnic cleansing, generate terror, and alter demographic realities. And this connects to debates about whether wartime rape should be primarily understood as gender-based violence or genocidal violence targeting a collective group. And the categorization has implications in many areas. So this would include legal framing, reparations, and historical memory. And the important concept that I also talk about in my other areas of research is this continuum of violence. So the three authors that I'm mentioning here argue that gender-based violence in Bosnia must be understood through a political economy perspective. So they define the continuum of violence as the structural reproduction of gendered violence across wartime and post-war contexts linked to informal economies and are sustained by militarized masculinities. So war violence and post-war inequalities are co-constitutive rather than sequential. And similarly, other authors demonstrate that post-war victimization includes poverty, domestic violence, and weakened institutional protection systems in the country. And thus, violence doesn't end when the ceasefire ends. It actually mutates into a structural and socio-economic form continuing after the war ends or even during the wartime. Now, during war, acknowledgeably and after war, there's some sort of gaps in the transnational justice system, including gender justice gaps. And Bjorkdahl and Manergren-Selimovic identified 3 gender justice gaps during this time, which was the accountability gap, which means that there's limited prosecutions, acknowledgement gap, which means that there's insufficient recognition of crimes that are going on against women or gendered violence, and the reparations gap, which means there's really uneven or absolutely no compensation for victims during the time. And so Static defines a gender-sensitive transnational justice as integrated truth justice, reparations, and guarantees of non-recurrence. Yet the implementations in Bosnia remain fragmented and uneven, and it's important to note that the legal successes of the ICTY jurisprudence on rape as crime against humanity has not automatically translated into social rehabilitation or economic stability. And what's interesting coming in this area of actually the Balkans is that there was an NGO boom, but this also kind of led to institutionalization of victimhood. So Helms describes this post-war NGO boom as heavily influenced by international donors. So these donors had narratives about framing women as natural peacemakers, moral authorities, and agents of reconciliation. Now, while this framing created opportunities and for women to speak out, it also risked depoliticizing women by confining them to moral rather than formal political roles. And victimhood became institutionalized, fundable, and standardized within donor frameworks. And of course, we can't not discuss memory politics in the context of this war and the aftermath, where the places became a place of pain and silence. So for instance, there's a really big research done on former rape camp sites as the places of pain that are often transformed into spaces of silence as well. So Bjørndal and Mannergren argued that spatial erasure and narrative silence co-produce memory politics, and there's this self-victimization strategies in post-war Bosnia, which included moral alchemy and double relativization, which reinforce ethnic boundaries through competitive victimhood. And also there is highlights that the paradox between international prosecution and local silence are actually surrounding this backdrop of sexual violence, and therefore memory becomes a contested political terrain. And of course, another factor that is more difficult to discuss, and not necessarily only with women, is also the consequences of rape themselves, which is children born of war. And there's a very good book that I put here on the slide called Forgotten Victims, Children Born of War, where Carpenter analyzes how transnational advocacy networks construct and prioritize certain victim categories. So she demonstrates how children born of wartime rape in Bosnia were marginalized in international rights discourse. And this illustrates agenda-centric dynamics and includes kind of this idea of visibility, who is visible in the political sphere. And children born of rape were often marginalized, politically inconvenient, or overshadowed by the focus on women victimhood as opposed to actually the children that could be suffering. And this directly coincides with hierarchy within victim recognition, especially post-war and victims of war rape. However, there was a huge political empowerment of women and women's agency that existed in the region. So despite structural constraints, women in Bosnia have exercised their agency, used their voice to promote gender equality, and stepped out against domestic violence and rape. So Schwartz and Taxiova showed how survivor narratives challenge masculinity, war histories, and reclaim subjectivity. And others have demonstrated that women's civil society organizations contribute to political empowerment by fostering agency, legal literacy, and networked activism. And Helms further argues that women strategically navigate essentialist representations to gain moral authority in a post-war context. So victimhood in this context is not solely imposed, but it can also be mobilized and changed in the future. So these are just my preliminary conclusions of the chapter that I'm contributing in our co-writing. So the evolution of victimhood in Bosnia can be traced across 4 phases, which I covered: wartime, which is victimhood throughout the ethno-national gender ideology; transitional justice, so legal recognition with persistent gender gaps; post-war political economy, so structural continuation of violence and how does that manifest; and memory politics, so this means that there's contested narratives and possibly ethnic backdrop related to this. And to understand women's victimization in Bosnia, we must also move beyond the binary victim and perpetrator narratives, war and peace separation and their reparations. And we cannot stick to legalistic definitions alone, because this is a very much complex issue that's happening. And instead, we should focus on intersectional and historically grounded analysis of violence, memory, justice, and the political economy. So thank you for listening, and I look forward to any questions you might have. And yes.
Slightly ahead of schedule, but our next final speaker for this session, also from Times of Hybrid Crises, Mariana Morieva, a law professor. Mariana, are you there?
Yes, I'm here, and my PowerPoint is shared.
Excellent stuff. If you're ready, the floor is yours.
Okay, yes. Thanks very much. Can you see the PowerPoint at all?
Just a moment. Just a moment, we'll get it.
Oh yeah, now I can hear you because you were a little bit distant over there. Okay, good afternoon, everyone, and I would like to express my gratitude to Katarina for organizing such a great conference so that we could share research from the Victim project as well as navigate the discussion on victimhood in historic, but also comparative and contemporary perspective. So my title changed a little bit. I've been working through the material, and in the end, I realized that being the last presentation of this conference, as well as sort of thinking about the day, what is the day today, I mostly focused today on victim rights in authoritarian regimes and what are the strategies that the regime uses to deny recognition of victimhood, which I hope is going to be useful also in our discussion, but also in our research. It has a lot of legal implications, and contrary to what I usually do today, it's a rather doctrinal talk. So I'm going to be looking quite a bit into legal theory and offering some sort of legal strategies of thinking about recognition of victims' rights. On my first slide, on a title slide, you can see two pictures which are actually quite interesting. So on the bottom of the slide, you can see the poster for remembering of the victims of political repression. And there's still an official Remembrance Day in the Russian Federation, which is 30th of October, that the community, the state, celebrates or remembers, rather, the victims of political repression, Stalinist repression, first of all. But then on the top, that's the new collage of pictures. There's a new political prisoners and who the state prosecutes for being in opposition, exactly, and very similar to what people on the bottom part of the picture are. And it's an interesting historical connection in between the two, which is ironic, of course, these days. So to kickstart the legal sort of analysis of victims' rights, there are a couple of key ideas. And of course, you all recognize the picture from Niels Christie's 1986. It's a little bit modified on the ideal victim. So victimhood is a legal status. It's not a self-evident condition, so it has to be recognized. And in this particular respect, authoritarian regimes control access to victim recognition, and they are key actor in how victimhood is defined. And although a lot of authoritarian regimes offer formal rights, therefore their constitutions, criminal codes, criminal procedural codes, or special legislation on victims' rights actually does have quite a good description and construction and guarantees for formal victims' rights, but they fail at effective protection of those rights, and they do it strategically. They also do it absolutely on purpose. So it's not just because they can't, or that's the way it is. And in a ideal victim characteristics, which a lot of authoritarian states also have as a concept, you can see several important points, which is the ideal victim should be weak or vulnerable, which is elderly, female, or a child, should be blameless and innocent, should be unrelated to the offender and harmed by a clear bad person. It's interesting that even back to Soviet victimology, these didn't work. They didn't work in the 90s. They surely don't work today in the Russian Federation. So that you never reach the category of ideal victimhood. But I would like you to remember this elderly woman who is now on the front line of the protest, actually, in the Russian Federation against the war, against oppressive politics. And no matter how vulnerable she is, she's never going to be recognized as a victim, or no matter how much state exercises violence against her, she's never going to be somebody whose victims' rights or who could be enforced or protected. So let's start a little bit with a conceptual framework. In authoritarian regimes, victims' rights are rarely just a matter of statutory entitlement. They operate as a status allocation problem. And there are three elements to that, three key mechanisms. You can see them on the slide. The first one is a recognition gatekeeping. So to exercise procedural rights, an injured person must be recognized as a victim. And in Russian criminal procedure, the word is потерпевший, so it's actually not a victim. And even the sort of linguistic construct is interesting. It historically also goes back to the Soviet construction of victimhood. So modern Russian law enumerates extensive rights once victim status is granted. It's under Article 42 of the Criminal Procedural Code. The second key mechanism and element is a prosecutorial or investigative dominance. Victim status and the opening classification of a case are typically controlled by investigators and prosecutors. These are institutions that in authoritarian settings are often aligned with the regime priorities. And a third key mechanism, as well as a part of the whole sort of statutory entitlement and status allocation theory, is that narrative control also goes aligned with the blame shifting. So the state or state-aligned actors shape the narrative of harm, frequently recording victims as offenders, provocateurs, or unstable, or responsible for their own harm, and thereby reducing the political and fiscal costs of prosecution and compensation. And as a result, that means that formal rights can coexist with systematic underprotection if access to victim status, effective investigation and enforcement is politically and or socially inconvenient. And that's the trend in the Russian Federation in the past 20 years, that all of these, both politically and socially sort of inconvenient reasons, lead to procedural denial and de-recognition of the victim status. So very briefly on a history of victim status, which originally was the purpose of this presentation, but I decided to cut it short. The modern genealogy of victims' rights in Russia begins with the judicial reforms of 1864. That's when victims were recognized as part of the participatory adversary process. The reform was the first moment when Russian law meaningfully distinguished between state prosecution and private interest harmed by crime. Therefore, victim became a figure of the procedure. Although under the Tsarist law, the pre-1917 law, the system remained hierarchical and the victim's role was subordinate to judicial and prosecutorial authority, and the criminal justice was primarily an instrument of public order rather than individual redress. Of course, with the Soviet, especially early Soviet criminal system, procedure rejected this liberal idea of adversarialism, and it rejected it in favor of a model oriented towards protecting socialist legality and educating the population. And within this framework, the victim was recognized as a procedural figure, but not as an autonomous bearer of enforceable rights. So the RSFSR, which is the Russian Soviet Federative Socialist Republic Criminal Procedural Code of 1923, and subsequent revisions acknowledged that the victim allowing participation in the proceedings and claims for compensation. And actually that became one of the most important sort of definitions, is the person who's been harmed and can claim a compensation. That literally two elements that Soviet victimology and Soviet criminal theory focused heavily on. However, victim interests were conceptually absorbed into the broader goals of a socialist state. Prosecutorial discretion and investigatory control sharply limited the practical significance of women's participation. Now, the 1960s brought a new redefinition of victimhood in a more systematic articulation of victim status. 1960 code formally defined the victim, provided participatory rights. A lot of those rights shifted into the post-Soviet era, and extended institution of civil claims within the criminal proceedings as a principal mechanism for compensation. After the collapse of the Soviet Union, a new constitution of 1993, the constitution that laid out a foundation for the democratic state, which is not the case anymore, both those chapters are still unchanged despite the 2020 changes. So the 93 constitution has two articles that constitutionalized victims' rights. Article 52 guarantees victims access to justice and compensation of harm, and Article 53 establishes the liability for damage caused by unlawful actions of public authorities. Of course, the most recent framework is provided by the current Criminal Procedure Code, the absolute recent changes in December 2025. And this is the code actually that literally extended the list of entitlements for victims since 2001 when it was introduced. So Article 42 gives a really long list. Actually, I just picked 7, but it's 21 guarantees for victims' rights. And among those, you can see that's information about charges, decisions, participation in investigative actions, legal representation, access to case files, support prosecution, etc., etc. And actually, back at the day, the whole idea was to implement victim-oriented approach, which was in line with international victim-centered approach theory, and we've heard quite a bit of it from Vyacheslav at the beginning of this session. But what happened again, that there was a formal list and it didn't have actually quite a lot of practical influence. The only thing that it actually provided is the access to information, but these days, again, the access to information is reduced. So what we see in a very brief timeline that I outlined right now, that despite formal guarantees and despite a long list of rights, what is absolutely obvious that this process of constructing victimhood is a state-centric. So contemporary Russian law offers extensive formal rights, as I've just said, but limit practical empowerment, particularly in relation to compensation and investigative control. And this trajectory is pretty important. So when you actually look at how it does that, there are a couple of things. One of them is a gatekeeping mechanism, and the gatekeeping mechanism works to reduce and limit a possibility of becoming a victim in a lot of political and public sort of crime contexts. So Russian criminal procedure vests substantial discretion in investigative bodies regarding the limitation of criminal cases. And when the allegation concerns law enforcement misconduct or politically sensitive events, refusal to open proceedings or repeated preliminary inquiries without formal case registration can prevent the injured party from acquiring full procedural standing. And according to the UN Special Rapporteur on Torture, Mariana Kazarova, you can see her in the slide. She, in fact, documented all the what we call gatekeeping mechanisms to initiate proceedings for survivors, for victims of torture, that would prevent them from actually obtaining a legal right, legal victim status. And once, as far as you don't have the poterpevsky status, right, you don't have actual courts to protect your rights. Not that it's very effective, but at least there is something. The other sort of mechanism, gatekeeping mechanism here, is very obvious in a domestic violence cases. It's what's called legal downgrading or reclassification. Authoritarian systems often employ legal downgrading, reclassifying conduct into less offenses or administrative violations. This technique narrows procedural guarantees, reduces sanctions, and signals institutional skepticism towards the complainant. And this strategy is particularly visible in both political repression cases, but also in domestic violence cases. And one of the big examples for the Russian Federation is 2017 domestic violence decriminalization of the first offense legislation that literally downgraded assault, light assault without physical consequences, Article 116, into the administrative assault. And these are very different procedures and very different consequences. But in terms of victimhood rights, it's interesting because the victim of administrative offense doesn't really exist as a concept. So in order to actually have victimhood rights, you need to be a victim of a criminal victim of a crime, and then Article 42 is applied. So that's one of the other sort of strategies how the regime could sort of deprive person of victims' rights. So let's look at those two cases. So I have like 5 minutes or 6 minutes left, so which is enough for us to go through a couple of cases. So case 31 would be political repression and state violence. And there are a couple of paradoxes here. So the one big paradox that you can see is that constitutional guarantees exist, but recognition of those guarantees actually threatens legitimacy of the regime. So 93 Constitution mentioned Article 52, 53 guarantees access to justice and compensation for harm, including harm caused by unlawful state action. But the state, of course, in the Russian Federation, especially authoritarian states, is not ready to recognize the unlawfulness of this action, and therefore it renders mute the provisions of the Constitution. So the constitutional framework on surface affirms robust victim protection, but when the state or its agents are alleged perpetrators, recognition of victimhood implicates institutional legitimacy and potential liability. A very good example is the law on victims, on rehabilitation of victims of political repression, that originally provided the procedures for recognizing, compensating victims of Soviet-era prosecution, mostly Stalinist purges, but also beyond that. So this framework demonstrates that victimhood can be officially acknowledged, yet it also illustrates that recognition of that recognition is historically bounded, administratively controlled. And in fact, once the regime escalated into this authoritarian state, and especially after attack against Ukraine 22, they literally stopped even using the law or recognizing historic victims of political repressions, because again, it undermines the whole sort of legitimacy of the regime. And on a slide, you can see how the numbers of political prisoners sharply risen up to 25, to just illustrate that the more political prisoners you have, the less the state is willing to grant any even leeway in trying to sort of take the state accountable for violence that it perpetrates. And of course, in the absence of overseeing mechanism, and that role belonged firmly to the European Court of Human Rights, that had done quite well in trying to make Russian Federation to at least pay remedies for violating human rights, Article 3, Article 4, Article 8, Article 2. So there's a lot of articles Russia was responsible. Article 6, Russia was responsible for en masse. Now this mechanism doesn't exist because Russia not only got kicked off the Council of Europe, but also Russia was actually preparing to leave, which also indicates that the regime wasn't happy to recognize its own violence perpetrated. Now, the second case study very quickly, unfortunately, is a gender-based violence case. So, as I mentioned...
Mariana, you actually are a little ahead of schedule, so you can unpack a little if you wish.
Okay, great. Thank you very much, Bran. Oh, once in a lifetime. So there are actually three interlocking strategies here in a gender-based violence case. So as I mentioned, there was a decriminalization of the first offense of battery or assault that didn't result in serious physical consequences. And I'm not going to go into the detail of what they mean by that. There is a commentary. And so the offense was downgraded into administrative offense. And this sort of strategy also downgraded the victim status and also the victim's rights. And of course, I mean, affected the whole sort of procedural matter of access to justice, and if victims, survivors could actually access any type of justice in cases of gender-based violence. Then Russia never had any comprehensive protective orders, and it had been a huge battle between lawyers, between international organizations, international lawyers, European Court of Human Rights, and Russian judiciary and legal system in terms of if protection orders could actually be implanted, because it's not a part of the Russian legal system, but also could be effective as an implant. Now, Volodina versus Russia is one of the last cases decided by the European Court of Human Rights in 2019, found that authorities failed to meet positive obligations to protect against domestic violence, and one of the biggest deficiency they named was literally absence of protective orders, which obviously had impaired victim protection. The third strategy here, sort of leading to downgrading the status, but also to procedural disappearance, is the ideological blame shifting. Now, there's a lot under authoritarian or conservative ideological framework frameworks, domestic violence is often reframed as a private matter. And it's ironic because since the Soviet public or sort of non-recognition of domestic violence, I would sort of shift it into this new regime. So there's a familiar rhetoric, traditional values discourse, and the whole idea is to shift responsibility on the victim, on the woman in this matter, and the responsibility lies with not the victim then, because the victimhood status then is not recognized as a victimhood status. And actually, this particular strategy is also very visible now in extremist legislation, in again political prosecution legislation, and even in the popular geopolitics that Russia uses on the international arena, always sort of shifting the blame to something else. So the cumulative effect of all this is the procedural disappearance of gender-based violence victims and non-recognition of them at all. And a big part of victims' rights, which is a compensation, is a structural dead end. Although, as I said, Article 42 actually has a civil claim and, say, the criminal case, but it all ends up in a very difficult strategy to claim. So offenders are often insolvent, they're part of the family, husbands, for example. You can't really sort of claim from the husband because then the money that are getting paid is your family money. You don't want to do that. State compensation is very narrow, and there's always an authoritarian filter in there. No case opened, no compensation pathway. And that also literally reduces constitutional promise of protection in reality to nothing. So to conclude a little bit, what we see in these two cases is two logics of procedural disappearance for victims. So the regime protection logic, in the case of political repression as state violence, when the recognition is denied to A, avoid liability, and B, simply to acknowledge the legitimacy of state violence, although it's ironic because the state doesn't need to acknowledge that. And the second logic of procedural disappearance is a patriarchal order logic. So in case of gender-based violence, there's a privatization of harm and blame shifting, which again to preserve hierarchy and to preserve the status quo of what the state already is. So common outcome, social harm exists, both judicial victims disappear, and literally in the end, this is all to just support the status quo that the state doesn't need to change or doesn't need to evolve. So in conclusion, hopefully, I've shown that victims' rights in authoritarian regimes cannot be addressed solely by statutory enumeration. In Russia, modern criminal procedure provides extensive formal guarantees, yet recognition of victimhood is mediated by investigative discretion, political sensitivity, and ideological framing. So political repression and gender-based violence demonstrate how victim status may be withheld, downgraded, or reframed through blame shifting. And the Russian experience thus illustrates a generalizable insight. Authoritarian systems often preserve the language of victims' rights while strategically controlling access to the status that makes those rights operative. And I would like to finish that there have been already questions and discussion a little bit how victim, so in case, well, it will happen, probably not happen tomorrow, but it will happen. The Russian Federation will need to actually compensate victims of Russian perpetrated war crimes and other strategies. So I guess that representation shows that Russia it does not have intention under the current regime to ever do so, because the whole strategy behind the recent developments, especially in the past 10, 20 years, that's under Putin's regime and under authoritarian regime, is in fact not to recognize or deny recognition to the victims that have sort of direct connection with any political or social implications for the state. Thank you.
Thank you, Mariana. And so, dear friends and colleagues, we seem to be a couple of minutes just ahead of schedule, so we will have a little more time for discussion. So we've had some very rich, very thought-provoking papers, and I hope we'll have some appropriate questions. And so please feel free to identify yourself. Yes.
Hello again. So we talked today a lot about victims, but the question that arose to me, maybe in general, is more than human rights. For example, we talked about people as victims, but what about land? Maybe it's a question for all like Ukrainian people, because war really affects also lands. There is a lot of let's say, species that will be endangered or are already endangered. And yeah, I know the war is still going on, but is there some kind of a talks about the land and how it can be, how it will be restored, or yeah.
Okay, maybe I will start just from here. Just regarding the ideas of land, nice position. Just I can't say that the definition of victim in international law or in the characteristics of just domestic law should emphasize or should be widened to just characteristics exactly of property. Yes, from our point of view, just Ukraine has special norms in our criminal code regarding ecocide, and that is why there's the problem of just war crimes in this connection should be solved very, very strictly, and that's why, for example, now we are discussing in due to transposition of Ukrainian law to European one in the context of just not only property crimes but exactly the context of European Directive on Environment and Environmental Crime of 2024, we are going to do the same. The second aspect of your question is connected with the position of property, and the position of property just under Article 1 of the first protocol. And we have a huge amount of cases, and now, for example, one of them is very specific. That is the case MSL Ltd versus Ukraine, under which the European Court of Human Rights said that there will be a violation of Article 1 because and Article 13, by the way, because of the sanction against juridical persons should not be evolved and should not be recognized as legitimate. And that is the case. That's why we are working on it. And just another problem just is regarding the European understanding of ecocide. And that's why we should be widening our notion, because we say it about only intentional ecocide. And sometimes in European norms, we're saying that negligence and criminal negligence should be the element of this proportional analysis too. Thank you.
Do any of our other speakers want to address that question? If not, I think we can move on to the next question or topic. Sure.
I would like to ask a question to our colleague Mariana Muravyova, because her topic of the report was connected and presentation was connected with totalitarian regimes and victims of it. I think it's very important, and we live between democracy and totalitarian regimes. And my question is connected. What do you think about special courts, tribunals, maybe international, like Nuremberg and Tokyo tribunals in historical point of view, but for communist regimes, because we haven't seen such tribunals in history? What do you think about perspective of it?
Thanks very much. Well, it's a great question. So the actually question of international tribunals for communist regimes was very popular in the 90s. I remember that very well, and I participated in a couple of those discussions. And it's interesting that we sort of forgot about it for some time, and with Ukraine actually didn't forget. So that's one of the countries that continued to try to, because of Holodomor, obviously, studies and so trying to get some historical justice. That depends on sort of the positioning. What's the approach to the special tribunals? The pretty rich literatures on that, what the special tribunals shall and could be applied to communist regimes. First of all, sort of the historical sort of literature of humanitarian law and international criminal law mostly focuses on the legitimacy of the communist regimes, and if communist regimes could be equated with the Nazi regime in perpetrating mass violence and sort of war crimes, in a sense that how they were prosecuted under Nuremberg Tribunal. And there are three big groups of scholars who say yay, nay, and well, let's see, each regime should be treated individually. Quite a bit of it is written on Cuba. So, the Cuba is a test case. So if Cuba could, as a communist regime, so shall it be then created a special tribunal to, say, prosecute Cuban communist regime for crimes against Cuban people? So that's one sort of piece of approach here. So the other piece of approach is, of course, connected with the Russian attack against Ukraine and the whole big question of special tribunals and how special tribunals can or cannot be effective in prosecution of crimes, war crimes and regime crimes against their own populations, but also the other populations. And again, there's a disagreement a little bit. There are a lot of skeptics who say, I mean, look what's happening with ACC. It's literally not proving to be an effective mechanism, efficient mechanism for prosecution of war crimes. Special tribunals even for Uganda and for Yugoslavia, although they did punish some perpetrators, but they did not actually grant the satisfaction of justice being achieved in these situations. Therefore, there's this quote unquote disagreement over there. And so I, unfortunately, side with those scholars who, fortunately, I don't know, who have expressed quite a bit of skepticism in do we need special tribunals per se as an effective, efficient mechanism of dealing with historical justice cases, because communist regimes are historical now justice case. I don't know, we have some communist regimes, China probably, Cuba, is two last ones. But is it an efficient mechanism? Is it a mechanism that would be good just for the satisfaction of getting a justice done by an international special tribunal? Or there are other mechanisms that have been used, for example, in indigenous justice, right, healing, and sort of looking into the wrongs done and righting those wrongs. Because what happens is we're so focused on justice, so the legally sort of provided, that we forget that a lot of communal mechanisms might be actually much more effective than the justice provided. So that, of course, is the sum up. You know, I can talk about it forever, but that hopefully answers your question.
Thank you so much. Thank you.
Yes, please.
I just want to ask Professor Shipika about, he was speaking about post-traumatic stress disorder what do you think, what should be done in Ukraine to create the mechanism for veterans to overcome these conditions of post-traumatic shock disorder? Because we can see, according to your presentation, that a lot of people are suffering, and especially veterans. How do you see, because, for example, in the States, there is some system, how it works in Ukraine? Thank you.
Thank you very much. This is very easy and very difficult question. And this is a big problem, but this is a psychological problem. This is a psychological problem, and this is many psychological problems with war and post-war period. And war period, but two victims, two group victims. The first, this is a civilian population, and the second group, this is a soldier. This is a soldier, but. Many aggression, many stresses, many apathy, and then maybe difficult activity and difficult resocialization in the civil life. And maybe this is a big long period and the problem with psychiatry. And we have some mechanism. This is psychological supported. This is personality and maybe rehabilitation. This is people. Rehabilitation, this is personal and helping. But this is syndrome may be not only a soldier and a civilian personality. And civilian personality, but every time some bombing, some rocket attack, and this is not good activity and not good influence for psychiatry. Thank you very much for this question.
Anyone else from the floor at this stage? Well, if not, as chair, I think I can pass a couple of questions myself. First would be to Yulia. Has your research covered, you mentioned sort of the local realities there, and it's come up in discussions of rape as a war crime in Bosnia, particularly when the victims were Bosniak, that is, they were Muslim women, that there was, if you like, a double layer to this insofar as allegedly their own menfolk would reject them then as a result of the fact that they had been victims. So they became double victims. Has any of your research encountered this?
Yes, thank you for the question. My preliminary research has, of course, touched upon this, and it's actually a pretty big issue, particularly because there's a larger Muslim community in Bosnia as well, so that we have seen evidence of this, that Muslim women will get rejected by their husbands, or also the children will be kind of not treated the same as a child that was not maybe a previous child that was not a victim of rape, and things like this have come up in my research. But yes, I would like to look at it more. And there's also actually reverse situation where, for example, Serbs were being also raped and things like that from the army. So then that community would also reject those women as well. So it's a very complex situation in that territory, especially regarding the situations when these women became refugees as well, because they tried to kind of exit into a better life, but also these problems followed them as well. And sometimes there would be more kind of domestic violence or partner violence from their partners because of this kind of rejection of these women that have also left the situation but were affected still by these rapes and other kind of situations where women were violated. Yeah, thank you for the question.
Anything more from the floor at this point? If not, I think we can go back to the piracy discussion, if I may, because it was very interesting having two speakers on this topic on contemporary piracy. I was sure, if we were going to be talking about contemporary piracy, that Venezuela might have been mentioned, or the flotilla in the Mediterranean Sea. And this, I think, brings up a larger question about, I'm being a political pain in the ass and asking this, I know, because I'm not a lawyer, but coming from a sort of being a political analyst, at what point is there a ceiling to international law? I'm reminded of, in fact, I'm writing a book chapter with the title Pirates and Emperors Revisited. It was the famous encounter which is recorded in St. Augustus' City of God, in which a pirate was captured by Alexander the Great. The pirate was hauled in front, and Alexander the Great says, "How dare you threaten the seas?" And the pirate says to Alexander the Great, "How dare you threaten the world? Because I do it in a small boat, I'm called a pirate. Because you do it with a mighty fleet, you are called an emperor." This does bring up questions in international law, as at what point does the exceptionalism of very powerful countries click in? There was no outrage about the acts of piracy that the Trump administration committed in Venezuela or off the Venezuelan coast, literally killing people in ships without proving that they were transporting drugs, double tapping, as they call it, which means double bombing it to kill anyone who's not killed in the first bombing, literally boarding tankers and confiscating the oil that was on them. So here we have state-level piracy. But where is the international outrage about this? Because the most powerful hegemonic state in the world is doing it. If any of the legal scholars want to grab that one. I know it's a big of a question, but... You're in danger of giving me the last word, which is never a good idea.
No, pardon me, but just maybe I can't follow this idea. Well, just when we're saying about government and piracy, okay, but do you think that, governmental deeds should be qualified as the same crimes as from individual or collective crimes? Yes, from one point, government is a collective subject, but from the other point of view, these deeds are legitimate, and that's all. If we are saying about the states and the season of Venezuela, that's one point, because they have a special jurisdiction, and this special jurisdiction is connected with so-called civil compensation and civil confiscation act. From the other point of view, when we're saying about just misuse of law, yes, or abuses of law connected with the case of state violence, of usage of martial law for ordinary people, I don't know, but there is a gap, and this gap is connected with the idea that sometimes, there will be an order to do that. And from one point of view, in times of war, or in the ICC, we should use the common responsibility. But should we use the common responsibility against, for example, the just minister of United Kingdom, yes, who just gave the order to just kill the terrorists. Or what should we do with the Soleimani killing when Iraqi state just, if I'm not mistaken, ordered $500 billion, sued $500 billion as a fine against Trump administration. That is always the case that should be analyzed in this situation. And by the way, the last but not the least, when we're saying about the intergovernmental violence, it should be connected with sometimes with the communication under diplomatic channels. For example, case Medvedev and all against Ukraine, or against France, pardon me, when Ukrainian citizen Captain Medvedev was seized by French special forces in Atlantic Ocean on the vessel, which was after that prosecuted in drug trafficking, and the case was connected with the idea that firstly the flag of the ship was silenced, and they received a special agreement. There was a special agreement to use force against the ship. That is why sometimes I could say that it is a hidden situation, not with the states and the states' abuse, but abuse of so-called white squads, paramilitary companies, and that is a huge problem for us. Thank you.
Yes, thank you for your comment. We still have a couple of minutes of discussion time left. Final question or comment from somebody? And if that's not the case, then I think we have the closing remarks. So I'll hand over the floor to Katrina for that. Thank you for all the speakers and the comments and questions in this session. It's been really good. Thank you.
Thank you so much for amazing moderation, and thank you so much for all speakers. And also for everyone who came on site or online, and for all your very interesting questions and very important questions to address this important topic, especially nowadays. And I also would like to mention that the Research Council of Lithuania, we are very grateful as a team for making possible to organize this event, this conference in the framework of our project, Victim Project. And in the framework of this project, we tried to build a bridge between history and legal science, between historical perspective and current challenges as AI, cyber attacks, and we try to kind of go deeply, starting from the roots of victimhood, to see from different perspectives, from different countries, not concentrated only on one specific regions, but to address different conflicts, different problems. And as well, we tried not to be only in the framework of science, but or in academia, but we also tried to build the bridge between academia and practice. And you can see that at the beginning of the event, we had distinguished guests, General Prosecutor of Lithuania and Ukrainian ambassador, and it's not, we are very grateful that they came to our event, and it's very important because we need to bring science, we need to bring our knowledge to practice and to work together, as well as we discussed, and we had a lot of questions with regard to justice. And of course, it's also a lot about political will to bring justice, to make it possible to have these big fishes, so-called, in the in trial in the courtroom. So for that reason, it's very important to have this kind of synergy when we have this deep foundation with roots and a different perspective, starting from history to current challenges, and with practice who are actually moving forward these kind of things and to represent in international political agenda, not to forget about these things. So on behalf of our team, of our project, and of our organization team, I would like to thank all of you, and especially to our shams also, who helped us very much during this event. Thank you so much for that, and thank you for all your contributions. And I hope that this is not the last event, and we will continue working. And also we are preparing the monograph, the book, which will be in which we will also address all these problems. So we will keep you updated on the web pages. Thank you so much, and looking forward for further cooperation. Thank you.